Okay, we'll go ahead and get started. Judge, you've been asked if you would mind sitting in that chair so that everyone can see you. Okay, Judge Anderson, all the council is here. City manager, city attorney, Judge Anderson with his quarterly report. You want to go ahead?
First off, I want to thank council for allowing me to come here today. I know, and I can see on the screen, you have Council University today. I know you have a rather robust agenda, and I think when Mayor Brinkman contacted me to set this up, I don't know that we actually knew that this was going to fall on the same date, so I'll try to get you onto what you want to get to. Originally, I think the purpose of the meeting that was requested here had to do with the actual court scheduling. However, I thought it might be helpful to do both that and the quarterly report, and you should all have in your packets copies of the most recent quarterly report, which has both the December 2011 compared to the December 2010, as well as now the complete 2011 versus 2010 reflection of the statistics. So, as you recall, when I did the report to you back in, I think it was probably May of last year, one thing that we noted was that there was a significant decrease in the numbers, percentage change in the right-hand columns because of the number of complaints that were being filed. I believe at that time it was about 35% across the board, and that was attributed mostly to reductions in staffing at the police department and some other kind of seasonal type things. One of the things that I was doing earlier this month was swearing in 3 new police officers. I think that the police department is still down 2. I think there's 2 more that are in training that should be coming on here shortly, and I believe from my discussions with the chief that that's going to bring us up close to the type of police staffing levels that I think that we'll see these numbers rebound or actually go back to what the numbers look like in 2010. But as this number shows here, the number of complaints that were filed for the year 2011 compared to the prior year 2010 was down about 26%. Now that shows that as there has been some increase in the officers, the number of complaints that were filed were going back up, although they were not catching up to the numbers that we had for the entire full year. But going from 35% reduction back to a 26% reduction shows that was increasing over the amount that we had lost. The number is broken down in terms of the complaints at the Violation Bureau, which are primarily the parking, as well as the ones that come into court that I would normally see. Those numbers also show a little bit higher percentage at the Violations Bureau. That would be consistent with the loss of the staffing of the parking officer as well. And the 23% is actually a little bit lower than the overall 26% there, reflecting the catch-up that we did there. So we really did see a kind of an increase back to the expected levels from what we had originally experienced at the beginning of 2010 for the first few months. The court activity, again, is a little bit lower in terms of the reductions. Pretty consistent once those came in, but if we're having a 23% or 26% reduction in the amount of cases that are coming in, we would expect across the board to see a reduction in the amount of guilty pleas, not guilty pleas, deferreds, and the like. And that's pretty much what we see. The mix is a little bit different, but by and large, that bottom line figure of court activity is pretty consistent. It's 21%, a little bit less than what we had before. Finally, if you go all the way down to the bottom, you'll note that the amount of revenues that were collected actually were an increase in terms of per case amounts that were recovered. But what I mean there is if you look, you'll see that for the year, the numbers were down 14%, which would be significantly lower than the 26% that we saw a reduction in filing. So that means on a per case basis, the revenues were up a bit. And I think that's probably mostly reflective of a full year under the new fine schedule, particularly the no insurance that was pretty significantly different from what we saw the year before and previous years. And that's now being applied fairly consistently for the year. So these numbers really, in terms of what I kind of expected we were going to see, pretty much reflect that. And I think that what we'll actually see as we start to compare equivalent positions for the next year, once the staffing comes back up, I think we'll see an increase in the amounts so that 2012 will look more like 2010 than it did 2011. If there are any questions about any specific numbers that are here, to the extent I can, I'll be happy to try to answer them.
And
yes?
you're reading something seeing it a little differently than I am. I'm looking back up at the complaints, and you talked about the problems we had at the beginning of for several months last year.
First quarter.
And then we started catching up. But it doesn't look to me like there's still a significant lag, December to December comparison.
Now, December is actually a little bit different month, and the reason for that is because of the holidays falling on the Mondays, which were regular court days. We actually lost 4 days out of December out of the 12 days we would normally had for Christmas, and then New Year's. Actually, I guess that's January 1st, but the way that it came down was on a Monday. And then the last two Thursdays in December as well, we did not have court days.
Okay.
So that's part of it, and that's all December.
The previous year was Friday, but Friday's not a big day for you.
Yeah, Friday we actually don't have court generally except for jury trials.
Yeah, well, thank you.
Jim, there's one other thing that we could hope for is that our citizens are more law compliant now than they were a year ago. We could hope for that.
Well, I always tell people if I didn't have a job because there was no lawbreakers, I'd be really happy because I live in one of the safest communities ever.
Yeah,
And,
right.
and I think there's a part of that, particularly with the red lights, the photo reds, and I know that's fairly controversial if you read the papers, so much more so in Denver because they're doing the white line crosses that we don't do here. But the whole goal of those things is to increase people thinking about it, and if those numbers go down and the revenue for those go down, that's a good thing because it means less people are violating that. That makes those intersections much, much safer.
Yeah. I live in a very walkable community, and I've decided that STOP means pause if you feel like it. Because there's a lot of stop signs in mine with a lot of crosswalks. And I notice all the time, it's just pause if you feel like it. You know?
Well, it's not too surprising when I see particularly stop sign violations as opposed to the red light violations. A lot of times I get a person that really seems to believe that they stopped, and everybody else that's viewing it saying, well, they kind of slowed down and looked both ways and kept going. And actually, on my way over here tonight, I saw exactly that with a car in front of me that didn't slow down a whole lot and just went right through it. And
It's not just stop signs, it's the red lights for the right turns.
Yes.
Is the part.
And one other thing, I know that there's some states back east that have state laws about the white line, the white bar stop line. That is state law. If your bumper is touching that line at all in a plane, that it is a violation and therefore subject to fine. And there may be more and more states who look at that, I think.
Bruce?
Couple questions. Help me understand or explain, if you would, well, take your explanation on the complaints filed issue. We did talk about this earlier in the year, although I want to follow up on that. But I would assume the complaints closed wouldn't be impacted much by the decline in staffing from the police department. Is that accurate?
well, it's a chain. To the extent that there's less staffing, there's less tickets that are written. To the extent that less tickets are written, there's less action in each of the variables here in terms of closing cases, trials, and all that type of stuff.
But wouldn't the time frames, I mean, you guys have enough staffing at the court level. If you started seeing the court calendar slacking a little bit because you had stuff running on, I mean, couldn't you just pull them forward so that you theoretically keep things moving faster?
Well, there are some requirements on how much time must pass before a case can come into court. So, for instance, if there's a ticket and somebody wants to pay it, I think it says on the ticket that there's 15 days that they have to wait before they can do that. And that's just a realization that the ticket's got to get back over to the police department, recorded there, transferred over to the courts, docketed onto the system, and then available
So it's
for them
pretty
to do.
linear is what you're saying.
Right. In municipal court, we have a 90-day speedy trial period. And so that's fairly short. So we process cases quicker than, say, the state system or certainly the federal system does, where cases would lag. And if you had a drop, it might take a while for you to see that and a while for that to correct. But ours come through fairly rapidly.
We know that from Canamar, right? So, anyway.
That's district court.
All right. I guess the other question is, if you're saying basically LPD was down 3, and you got a 26% drop in complaints filed for the sake of an argument. That sort of implies there's 12 officers out there giving tickets, but I don't know what the numbers for LPD are, but I would assume there's more than 12 traffic staff.
I think if the police department was here, they would say that they have officers whose primary dedicated activity during a day-to-day is to write tickets, and when they're short, they have to remove officers from that role and put them more in a general patrol role where they write very few tickets comparatively.
All
I think
right, but
that's
does
what
it
they
make, I guess what I'm trying to do is, what you're saying is what you communicated back in May. And I think my recollection was we were thinking back in May that the trend was maybe going to pull up sooner than it did. And you're saying it did because we were at 35 and now we're at 26. But I guess I was thinking the curve was maybe going to be a little bit steeper on the rebound. So I guess I was trying to, and I don't want to put you on the spot, but there's somebody else here from.
No, and if I can respond slightly, I don't quote me on this, but I believe that it's only very recently that we've actually become fully staffed again. And so I think that if the chief were here, she's out of town, so she couldn't attend tonight. Sure. But if she were here, she would say that she would concur with the council member that it's been a staffing issue in trying to get people on the street. But okay. I think
I swore those officers in November or early December, and there was 3. And the conversation I had with the chief at that time was that they were down 5, which represented a team. And that they had, just like Councilmember Beckman said, they had transferred some of the people that were doing primarily traffic ticket writing to doing general patrol. And there's 2 more that are in training that should be coming online, I think, within the next month or 2, and that's when they're actually going to be back to that level. So really, for most of 2011, they were down. So
then your expectation is, and I think this is what you said, if I recall, it was you would expect 2012 to be probably somewhere in between 10 and 11, given you've got maybe some of the red light photo op issues. More or less, you would expect it to get closer to 2010 than 2011.
Exactly.
Okay. Thanks.
Yes. Jim, you know my pet issue is the inventory of items that are outstanding and what's leakage in the system. And, we have this objective towards 90-day speedy resolution. Sometimes it's to trial, but trying to wrap everything up. So help me with this as I just quickly look at the numbers to try and say, what's our inventory of stuff that's still on our shoulders that we haven't dealt with? So and maybe there's other leakage, so I just want to understand. So if we take a look at full year 2010, we start with 12,886 filings with 12,753 complaints closed. So that would mean there would be an increase in the inventory of those things that are still on our shoulder of about 130, 135, 145, but right, or 25. Okay, and then I take a look at 2011, and I look at the schedule there, and we have 9,514 filings with 9,249 closed. So we have an increase of 265 or so in our inventory. So over the 2 years, we have somewhere close to about 400 increased somewhere on our shoulders, unless there's some leakage that I'm not seeing in the numbers.
There is, and what that represents are warrants. Because we have a backlog of warrants, and that's something that we've been working on pretty regularly since I've been here, because there are different types of outstanding warrants that are there. There's the failure to appear warrants. There are the outstanding judgment warrants that go to the DMV on traffic infractions. Those cases, because there's a backlog of those things that exist that don't represent a new case. Mm-hmm. And they're fairly significant in terms of the numbers of cases, that they would exceed kind of the numbers that we have now because they go back so far. But I know I just went through this past week outstanding warrants from 2006, and those were on a 5-year schedule for review and closed a significant number of those cases, something on the neighborhood of 80 to 90% of them, because they were simply well, we took, about half of them were cases where there had never been a resolution, and we sent those to the prosecutor to see if they were viable cases, if you still had the officers and the witnesses and the like. They closed, I think, nearly all of those cases. Given the amount of time, they weren't prosecutable. The other roughly half were cases where they were either old warrants for, in some cases, minor issues, in some cases, traffic offenses, things that were warrantable, where I made a policy decision, whether to keep it open or not, given the likelihood of any progress on those cases. And the more serious ones, I kept open with those warrants, and some of the other ones were closed out. Because there's that backlog of warrants, those cases can come through in the number you see for total complaints that are closed, but they will not be reflected in total complaints that are filed because they're already in existence at the beginning of the year. Now, the question that you've asked me about inventory, and I've looked at this, I've talked to Pat Spindler, the court administrator, about this. We can take a snapshot of what our caseload looks like right now. And to an extent, that's the numbers that you're seeing here because they're generated off of the current active cases. But if I try to go back, say, to January 1 of 2006, there's no way to capture a picture of what the caseload looked like at that point because it's fluid. And once that case, if it's a warrant back there, is closed, there's no way to know when the totality of those cases were closed relative to the rest of them to get that snapshot. And that's the frustration. I know what you've asked me to do, and I've tried to see if we can do it, and I don't think we can.
But if I take, if I understand what you're saying, which is dated, meaning back, warrants that are closed will show up in the closed statistics.
If they come through this year, yes.
Right. If they came through in 2010 or 2011 and they were closed, okay, they would have shown. So in effect, if we look at those complaints that were filed in 2010 and 2011, the backlog grew more than 400 because there were some that were closed from prior to 2010. Is that right?
Correct.
So if we look over that 2010, 2011, there's been, that's why I said this, the snapshot, that's what I'm trying to get at, okay, is there's something in excess of 400 that has grown our inventory at this point in time that we have somewhere on our shoulders. And then what, knowing that you do this review, it sounds like we have a higher inventory of unresolved issues. We're trying to increase our efficiency and our throughput, but the inventory of what's outstanding is growing.
But the one thing that I'm not sure of that would answer that question, and I'd have to ask Ms. Spindler about this, and I've not done that, is if the numbers that she shows for total filings and the numbers that she shows for total complaints are only current year cases. Or if that includes because I would expect from the number of warrants that we closed out over 2010 and 2011, I would expect that the number closed would exceed the number filed, particularly for 2011. But if what she's doing to generate this report is taking them off of new filings, that would not reflect what I'm telling you.
And that would make a difference in what he came up with, too.
Yeah, because what he's saying is I see that these numbers are smaller, and that means that there should be additional cases over and above the complaints filed. I know that we've been closing out a lot of old warrants.
I know what you're saying.
Yeah.
What I'm trying to do is say, geez, when we look at the numbers, if I look at this, we have this increase over the 2-year period of 400 that are in that inventory.
Right.
Just taking a snapshot from 2010 to January 2010 to December 2011, the numbers indicate we have a 400 increase or so in our inventory, and that doesn't mesh up with your sense
Right.
that we're closing more than not. And that's where I'm having trouble with the statistics and trying to understand what's going through. I
understand what you're going. Let me ask her that and then get back to council on where that number derives, because to me it is counter to what my expectations would be.
That's what I'm saying. There's something that doesn't add up. It's either in the way the numbers are being captured or something's going on, because there's somewhere that they're tucked away, and that's my question.
Yeah.
Bruce.
Can you take that discussion a little further and talk about, under court activity, warrants issued and warrants executed? the difference between 2010 and 2011, particularly in the warrants executed, so that I understand what that term means, because that's a considerable difference. That's probably the largest variation on the page.
That's a good question, and I'm not exactly sure. Generally, warrants issued is the number of warrants that we would probably FTA and arrest warrants, the combination of those two. I don't think it would count the OJWs because I think I saw those under a different line. Those would be the outstanding judgment warrants that we send to DMV to notify them of someone failing to appear. The warrants executed, I would think, would mean the number of people that are arrested on an outstanding warrant.
It cycled back into the court.
And comes back in.
That's the way I interpreted
Right.
it, but that's
And
a
that-
considerable difference.
Well, obviously, the biggest number there is the number of warrants executed. That actually would be consistent with what I told Councilmember Sinanek, that we've reduced the number of warrants. And if the number of overall warrants are reduced, then the number of arrests on warrants will be reduced. And I know also, and I'm not sure on the timing, but because we decriminalize certain things that used to be warrant arrests, and some of these numbers precede me.
Right.
I know historically the number of executed warrants should go down because things that there used to be arrest warrants on, like traffic infractions and some general offense ones, are no longer warrantable offenses. Those warrants have been dismissed, so there will no longer be arrests on those warrants.
Thank you.
But wasn't there also some, this is where some of the cleanup issue came in,
Right.
especially in 10. I
Right.
thought I recalled that.
Yeah, there was a significant number that were dismissed or that were vacated if the cases remained open for collections. We may have kept the case open, but we vacated the warrant. So it wouldn't be an executed warrant.
Okay, thank you.
Okay, any other questions?
I thought I'd take this opportunity to let the council know, and the judge, since I haven't talked directly to you as well, with the exit of our deputy city manager, the courts are going to be a direct report to me, at least on a temporary basis, and as part of that, we're going to be doing a full, I don't know if inventory is the appropriate term, but do a full analysis of our process and procedures as a component of having me take a full set of, new set of eyes look at that. And so I'll be working with the judge and the city attorney's office and our internal staff on looking at that process. We're doing, as an example, we're doing an update on the municipal court software this year. And so that's a great opportunity to look at how we run things through the system. Are we tracking things in a way that meet the judge's expectations, the council's expectations? So expect to see probably some code amendments coming through as well tied to this. We're also obviously working with the prosecuting attorney and some of the items that she'd like to see amended as well. So just want to let you know that there'll be a lot dealing with the courts coming forward with you before long.
That was one of the things I was going to get to, was the change in the software. Well, I just mentioned the last time I think I sent out everybody a copy of the goals and objectives and some of the ones that were ongoing. And talking with Ms. Spindler earlier this week, the next big thing she's gearing up for is a change in the court software. And that's going to be pretty significant. I think it'll take 2 or 3 months to be able to do that and to get it online and tweak it, because there's always some problems when you get something that's this new to make it work. So that's something that should be coming up, and I probably have a better idea of that by when I come and see you in May. And also the collections. Now, the collections, the contract was signed in late 2010. It's been brought up. We had someone from the collections agency come in to the courts where we identified the first round of cases that were going out. It's a little early to be able to tell. I think we only had I think it started in late November, so we haven't really had 2 months to really compare to see what those numbers are going to look like. Ms. Spindler indicated that she thought probably once we had 4 months or so, probably by the end of the first quarter, we'd have a good idea of what that looks like, since we'd have at least be able to compare March to January to December, and to get some numbers together and look what that is doing and what type of numbers that's generating in terms of the collection of those revenues over and above what we're doing with OJWs now and regular warrant arrests. So I'm looking at so far the numbers seem to be promising. There have been some side issues that have come up that we didn't expect, but anytime you have something new, there's going to be some things you're going to have to look at. It's just simply a matter of bringing a new process online. So.
Just one more comment on the difference in the number of warrants. I don't know where the program stands now, but there was an understanding that if someone from the courts was to call somebody and just tell them, hey, don't forget you have court coming up next week, there was a number of failures to appear that you could keep from happening because the person just totally was not going to be there otherwise unless they were reminded, and you could cut down on those, and then that side effect was you had fewer coming in front of you, less court time, and ultimately they weren't ending up in the county jail if that was an issue. And so I don't know where that program is, but I know it's a great program that other courts have used to try to cut down on the work.
Now, the county courts, and I worked with a program like this out in Golden a few years back, actually had a person that would basically sit there and call people by phone to remind them of it, and they saw a pretty sizable, a significant reduction in the number of FTAs. We don't have the staff to make the phone calls, but we do have a letter that we can generate, and it's been my procedure if someone fails to appear, if it's not a bond case where we have to act right away because of the status of the bond citation and to the surety and notification, that we send out a letter to give them a notification to come in. And I've seen a good number of people that have come in within those first 10 days where we haven't had to send out a warrant or haven't had to send out a outstanding judgment warrant to DMV on some of those cases. That has really helped, I think. And it's kind of the same idea done just slightly differently.
Are you doing that now?
Yes.
Not working that well.
Excuse me?
Doesn't seem to be working that well.
You forgot to appear.
Well, I know when I was in Golden as a prosecutor, I thought, the idea of a program like this is to get down failures to appear and warrants to zero. And I was surprised when one of the judges there said, well, there's always going to be a certain amount of failures to appear, and you just have to get it to a balancing of where the effort and the cost that you put into it gives you the benefit of the reduction, and it's never going to be zero, although you hope to approach it and have a reasonable amount. You can call someone, and I know I've had cases where I've had the clerks actually call because it was someone that had been into court. We sent a letter, and I know that this person isn't taking off, and they say, oh, yes, I'll come in Monday, and we hold the case for Monday, and they don't come in, and they don't come in Wednesday, and what happened? There's certain people, even if you call them, they're still not going to show up.
I guess my comment would be if the calling works better than the mail, then the calling might be a better approach to do. It sounds like, to improve, because it is a waste of resources to not have to have the no-shows. So it might be something you might look into and just see if there's a way that you can manage some resources. I don't know how many phone calls it would be. Most of the time, you probably just end up leaving messages anyway, but it might be something that in the end would pay off if it's already been successful in other places too.
And there may be a way as we go look internally in our process that we can use technology to assist in that. Not necessarily that a lot of these folks have emails or anything, but just, again, bringing in IS and seeing if they can assist us as well.
Bruce?
Did you mention, and maybe I missed, in terms of the warrants issued, how many of the 456 are failure to appear? Relative, what was the year over year,
I would think that the bulk of those are, the type of warrants that you're seeing there are going to be a failure to appear warrant at some place, whether it's, initially up front or it's at a trial or something like that, or a warrant that's been walked through by an officer. And I would say that probably happens maybe once or twice a month that they would walk a warrant through. So I would say that the bulk of these are failure to appear warrants.
So 456, it's almost 2 a day. You think you get 2 a day of these? If you guys are open 5 days a week, which you're not.
I would say, boy, the thing is there's different things. Different days of the week that we have the failures to appear on. The Wednesday is the biggest day. We'll have anywhere from 50 to 120 cases per week on those Wednesdays.
All right, so times 52.
If you took that as a week, that's about 8 a week.
Yeah.
That certainly would be realistic, because any general offense case, any traffic offense, which includes the careless driving, the no insurance cases, are potential warrant cases. And that's on an average of about 8 a week.
Almost 9.
Yeah.
The 685 from the year before was about 13, I guess. So, that order of magnitude sounds,
That does not sound surprising.
but you don't think you can get it, you think if you called them, you could get it much below 8 to 9? 6 to 7, 5 to 6?
I'd have to talk to Ms. Spindler about what kind of numbers we're getting in, because obviously I'm not there every day, in response to the 10-day letters we send out as compared to the numbers. There's sometimes where I'll have her call, but most of the time we do it by letter. I'm not sure what the percentage of those is compared to each other. But when I look at it that way as 8 per week, when we have 120 on a Wednesday and another 40 or so on a Thursday and another 20 or so on a Monday, those numbers are not out of line with my experience over the last 25 years.
It'd be interesting to get the stats and sort of see how many people show up based on the letter.
Yeah.
Michael?
Another piece, and this goes back to Councilman Cernanic's question, I'm not sure that the number is sufficient or is substantial, but we are still working through the parking tickets issue that we've had, and that's one of the things we're taking a more proactive action on, looking at that. And Judge, I don't know how familiar you are with that, but we definitely still have some of those that are outstanding. A lot of those cases, I haven't gotten the full report, but I've got a couple, and it appears to me that some of those might show as open cases as well, so those numbers will be reflected in the in not within the complaints closed, but they probably should have been within that. And so next time when we come before you and do a municipal court update, we'll let you know what percentage of those that were there. Those are going to be closed out, as I think Council's cognizant of, and we'll be putting together the refund process for those that paid within that period of time that they were not required to pay, and then close those out and show them as dismissed so that that doesn't reflect poorly should they arrive at our doorstep again in the future. So,
Judge, did you have anything else?
That's all I have, unless there are other questions.
Bruce?
Well, I was just going to ask about we've had conversations about the calendaring, and, is it our understanding at this juncture that you're going to move to the 2-month calendar for February, March, and that's pretty much going to happen?
Yeah, it's already, as soon as I got it, Ms. Spindler was gone for the end of December, so I didn't get to talk to her until she was back in January, but I already provided to her by the time she came in the calendar that I had for February, March, since we'd already done January.
Okay.
And that's being followed up. I guess I can respond to one thing about that. I think that originally the idea of the 2-month calendar was to try to mirror the calendar that was done in Aurora, because certain of us, of the judges, worked out there, and they had a 2-month calendar. But so, for instance, they do the odd and even months. So January and February was in the calendar that they get. I don't have March's calendar for Aurora, so I'm kind of in the dark in terms of what that's going to look like. So the idea originally was to mirror those two, to do January, February together, and March, April together, and like that. But since I got it and it said 60 days, I already gave them March, even though it doesn't have much information behind it.
Okay.
So, and then, as I get the next schedule for Aurora, we'll have March and April on it. So I'll have that April one within time.
All right, and you're okay with the concept per, I think, the communication from us that Judge Julie Anderson gets first crack at whatever you're not using, and then it moves off to the other 2 relief judges?
It's always been done that way.
Okay.
I mean, it hasn't, that wasn't what I was originally told to do, but that's what I did.
Okay.
And so, and that included January and February and March. And
Okay.
well,
And you had given us a letter on that. Did that come from Judge Anderson, or did that come from you? That told us on how it was already being addressed and who was declining or accepting?
That was from us to Judge Anderson.
No, I thought there was a reply of some sort.
I didn't issue any
I didn't.
reply.
I'll look into it. I'm not sure what you're referencing, but I'll look into it. And if there's something, I'll refresh my memory.
Thank you.
Okay. But there's no question, I mean, you're clear on that whole concept?
Yeah, that's originally what this meeting was going to be about, and what I wanted was direction. And Mayor Clark had indicated to me way back in, I think, August, that this is something that the council needed to address, and when I talked to Mayor Brinkman, that's why we set this up, and I just wanted a direction so it was clear, and I think that it's clear.
Okay.
So, and I don't have any problems following that, and to the extent that council modifies it, we'll follow that as well.
Great.
So,
And then I just think one more point to make clear, that if you should have any questions regarding that letter or anything else, that your direct communication should be to council, as opposed to perhaps the city manager or the city attorney. We will be putting together a bit more tighter protocol regarding that, but it's just keeping those lines of communication more pure, I think will keep messages more clear.
and I think that's a benefit to all of us, because knowing what the procedure is and the protocol is certainly helps, because in the past, it's been kind of a mixed bag, and I would much prefer a clean procedure. So,
Okay, if there's nothing else for the judge, thank you.
thank
Thanks,
you.
Jim.
Thanks.
Do we want to do bills before we
Yeah,
break?
sure. Yep.
Councilmember Ternanek do you want to talk about the South Metro Chamber, and then we'll break for dinner, and then,
We can do that. I mentioned at the last council meeting as part of reports that the South Metro Denver Chamber of Commerce is undertaking an effort to interview 1,000 primary and major employers in the South Metro area, primarily focused on the I-25 and Santa Fe corridor, with about a 3-mile wide swath around those. So basically it incorporates a lot of the city. At that point in time, I didn't have the list of, and it's still a working product, but I didn't have a list of Littleton employers that they were looking to include. I shared that list with the city manager and the director of business and industry affairs to take a look at. I haven't had a chance to talk with Michael, but the list is about 40 employers that are on that list. It's still a working list. It could grow some, and we can add other employers if we would so like. The ideal interviewing team, as this is being driven through the economic development group of the chamber, would be a member from the chamber. So that's a member from the chamber, a staff member from the chamber, and a local official. And so with that, I don't know, did you make copies of the list, or?
I did not.
Okay.
Did not.
What we have the opportunity to do is express where we would like to be involved if you wanted to be involved with a particular employer. The one caveat that comes with that is you would need to go through their certification course around the interview, because there are some components to it. One is that the information in the interview is going to be held confidential, specifically confidential in that. That the interview is not a time to resolve issues, but to focus on questioning for clarification, and then possibly delegating outside to other folks for resolution or communication. I can underline that one specifically. I participated in an interview of a major employer in the city of Littleton, and the individual's perception doesn't mesh with my understanding, so we deferred that to a subsequent group discussion with the appropriate folks from the employer, and then possibly appropriate folks from the city staff to be involved in that. So that was a part of it. And then the third piece is they're using a technology called Meetup that's going to be capturing the interview. They have a structured interview approach, but that's not particularly religious adherence to that particular guideline for the interview, but they're using that as a way to capture it. The period of time for the interview process began in January although there were a few test ones that they did in December, through October. And the Chamber's objective is to pull the information together in time for the next economic development breakfast that the Chamber would sponsor. So it would have that information from direct interviews with employers in the South Metro area. As I mentioned, different cities are addressing this in different ways as to how local officials would be involved, and are also doing some complementary activities. An example of that is the city of Centennial, Greenwood Village, and Lone Tree are collaborating together to send out an asynchronous survey to all of their employers. The response to that survey in survey responses is not going to be anywhere even close to 100%. That's why they want to have the direct interviews in conjunction with that. It's using the asynchronous survey that was developed at the State Economic Development Office sometime in 2001, 2002 is my recollection for the time frame on that, but I can be corrected on that particular time frame. So the question to the council, because our city manager is going to be looking at what the staff might want to step up and do and can handle within their bandwidth without any terrific disruption. Did I use that?
That is accurate.
Okay, would be to the council is, would you want to participate as a local official? There is a list of some of the employers that would be on the list, and to say if you had some of that, recognizing if you commit to participating in that, you would need to go through the training.
And I can get a copy of I was dealing with print issues, but I can get it tonight, so you guys have that.
Okay, and that's the question on the table.
Did you say, and maybe I didn't catch it, what's the timeline, or how much of a time commitment is involved in both pieces you talked about?
Not counting transportation to and from, the interview could be as short as probably a 20-minute conversation. But the one that I've participated in extended to about an hour, but there was a hard close, respecting their time. And they had actually scheduled it for an hour.
Was it at the chamber?
No, this is actually going to the site of the employer and being in their environment. And it's designed not to be as much the lieutenant, but trying to catch the top folks. There's no surprise that one of the major employers that's in the city of Littleton is Dish, is EchoStar, and the target interviewee in that instance is Charlie, and I've tried to manage some of the expectations on whether we're going to get directly to Charlie on that. But
How long does the training take?
the training was, I'm thinking it was an hour and a half session.
Okay, yeah,
So,
I'd be up for it.
and so if you wanted to sign up and then view the list and express that, during my travels, if you can get that information to Michael, I think that would be.
Could you send around, or you're going to send an email to reply to you?
I can if there's, I mean, if others are interested, otherwise I'll just work with you, depending upon what other
Ideal.
folks.
Well, this might also be something where we don't have to give you an answer tonight. It sounds like
Although it
might
would be
need to
soon,
do a
because
little-
this is up and running in this, but I didn't want to bring it to council without actually knowing what was involved in the training and having sat through an interview myself for that. The folks, I'm duly participating because I will get assigned 10 employers, and the objective is to have 100 folks from the Economic Development Group each do 10, so that it would turn out to be the 1,000. And what we don't have yet is how much the city might want to augment because of our regular contact with employers through the BIA director and his department.
And we don't have, correct me, but there's not 100 people, so that number might be pressed up for you right now.
Yeah, although they're still working on that part. That's because they haven't done all the training yet. So I went through the first training, which did have 35 folks, and everyone in the room committed to at least 10. And the city official from Centennial expects to do 50 herself. So But that's the time commitment that some of the other cities have committed to their staff. So she said this is going to be a big part of what she's doing. That's Corey.
So should we contact you for?
Given that the limo is picking me up at 5 o'clock in the morning, and I've apprised Jeff Howell, who's the coordinator at the chamber, that he'll be in contact with.
Okay,
either the
so we'll
city
get in
manager
touch with Michael, and within the next 2 days, is that good timing, or by the end of this week?
That's fine, because what you want to do is then get tied into the next training session.
Okay. So if you're interested, then contact Michael and do it before the end of the week.
Yep, and I'll send all that to Jeff, and then he can coordinate through me on when the training is and set all that up with you.
Okay, perfect. So if there are no more questions on that, let's take we're going to work through dinner?
Yes.
So we'll take.
You guys get to sit and watch, so.
Okay, perfect.
that's
We will
questions.
reconvene then at 6 o'clock. So dinner is in the hall. Grab your plates and then come back in.
should I do?
Okay. Should I do?
Are you?
Okay, we'll go ahead and get started. Kirsten, do you want to get us started?
I know, are we on?
Okay, we're starting.
Okay, so I know you've all been on the edge of your seats waiting for this riveting night of legal training. We have Tammy Tenoy, who's going to do some of her own introduction. This is a great opportunity for you all to go back to some basics about working within the scope of your policy-making authority. And there really is no one more qualified to give this presentation than Tammy Tenoy. I was fortunate enough to start my legal career in private practice working for several CIRSA attorneys. And CIRSA handles some pretty tough cases, and I'm really excited for this opportunity to have Tammy Tenoy present to you tonight. Tammy, welcome, and thank you for coming tonight.
Thank you, Kirsten, and thank you very much, Mayor and members of Council, for having me out to talk about Council University issues. Just by way of additional background, Councilmember Taylor reminded me of the start to my legal career many years ago when I was the staff attorney for the Colorado Municipal League, and I was privileged to serve Councilmember Taylor on the executive board at that time, and that was quite a long time ago. And I went into private practice after that, where I was a municipal attorney serving 9 municipalities along the Front Range, and so my background really is entirely in municipal law and municipal government. Please bear with me as I try to operate 2 pieces of technology. I actually had to spit out my gum because I knew there was no way I could deal with that on top of this. But just by way of background into CIRSA, we are your public entity property and liability insurance pool. And so the city of Littleton, along with 245 other member municipalities, belongs to CIRSA for purposes of your property coverages and your liability coverages. And so if a building falls down or if one or more individuals in the city are sued, then we are there to back you up and to protect you. Just a little bit of additional background into CIRSA, because one of my pet peeves is to hear CIRSA referred to as an insurance company, which, in many ways we resemble, but we actually are not. We're created by intergovernmental agreement, and so we are actually a public entity, and we're member-owned and member-governed. Our board of directors is made up entirely of municipal officials elected by and from among our municipal membership. Our sole reason for existence is to protect our member municipalities. So we take in money, we purchase insurance coverages on your behalf and administer those coverages. And if there are monies left over, why, we return them to our members. Over the course of our existence, we've actually returned over $30 million to our membership, including the city of Littleton. So we have a number of topics to cover tonight, and I'd like to propose just a few ground rules. Number one being, please do interrupt me with any questions or clarification or further discussion that you would like to have. I really do enjoy and appreciate an interactive discussion. I know from observing you earlier tonight that you will listen to and consider one another's viewpoints with open ears and open minds. I'm here as a training resource and not for purposes of legal advice. You have very well-qualified counsel to give you legal advice, as well as a very well-qualified manager to give you management and professional advice. And so I just want to give you this huge caveat that in case of any conflict between anything that I say and anything you hear from your city manager or your city attorney, why, their advice always trumps over anything that I might say. And then finally, I would like you to look at issues from the big picture view and prospectively, as opposed to focusing on things that may have happened in the past or that may be currently ongoing, so that we can take kind of an educational big picture of the issues. So in terms of the topics that I'll be covering in the next hour or so, I'm going to start with a quick summary of the Home Rule Charter as it relates to organizational structure and roles. Next, I'm going to very quickly cover the Council Rules of Procedure, open meetings issues, electronic communications issues, some ethical issues, and then finally I'll close with some liability suggestions, and I hope to kind of marry up the prior discussion with some of the liability suggestions that I make to governing bodies. So let's quickly start with the Home Rule Charter. This really is the primary document that sets forth roles and responsibilities and allocation of powers and limitations on those powers. And in my view, keeping faith with the Home Rule Charter really is a key citizen expectation. The Home Rule Charter is the citizens' vision of municipal government, and so keeping faith with the Charter is the way in which you keep faith with that vision. It also is, not incidentally, a prescription for maintaining your liability protections. So keeping faith with the Charter is a way in which you can continue to maximize your own liability protections. Yes?
It may be a term of art, Tammy, but I find when I talk with attorneys, there's an opportunity or there's a story behind that. When I hear the term keeping faith, it's not necessarily what I have experienced in the context of legal considerations. So maybe you could spend a moment just expanding on when you say keeping faith with the Charter. Tell me more. What does that mean?
Sure. That's a good question. I'm not really sure why I use that terminology, but, you know, as I see it, the Charter sets out who exercises what powers, and it sets out the key limitations on how those powers are exercised. And so there are things that individuals who have roles under the Charter can do that break faith with the Charter. And I'll talk a little bit about that and give you some more examples as we continue our discussion. But one that comes to mind in some municipalities, and keep in mind, I really have little to no background of the sort of tapestry of the history and the present and the future of Littleton. And so my examples are drawn from my own experience as a municipal attorney serving certain particular municipalities. It's also drawn from liability cases in which I've become involved as SIRSA General Counsel. But one of the common charter violations that I see is crossing the line. Your role as elected officials really is primarily legislative and quasi-judicial. And so one way in which you can break the faith, as I see it, would be crossing the line into administration, or crossing the line and reaching into personnel matters that really have been given over to the city manager in your charter. That would be another way to break faith. And so, for instance, reaching into personnel matters that are below the level of your own direct reports would be a manner in which you would not be keeping faith with the charter. Do those give you some examples of what I have in mind in terms of keeping faith and not keeping faith?
Yes.
Great. Thank you for that question. So as I see it, the charter also sets out the essentials of everybody's job descriptions, everybody whose jobs are addressed in the charter, and that would include the mayor, the council, the city manager, the city attorney, the judge. Those are the key positions for which parameters are drawn, authority is allocated within your charter. And of course, boards and commissions have certain responsibilities pursuant to the charter and the ordinances that you establish, which delegate certain functions to those boards and commissions. One really important thing to keep in mind about the charter is that as a point of legal interpretation, it's thought of as a document of limitation. In other words, the idea of home rule is found in the Constitution, the Colorado Constitution. And when the citizens adopted your charter, what they were doing was saying, okay, we will adopt home rule in Littleton, but subject to these limitations. And so the charter should be viewed in many ways as a document of limitation. So under the charter, the council's responsibility is primarily for legislative matters. There are a couple of sections of the charter that spell that out. It calls for a president of the council, and I understand that colloquially the position is referred to as mayor. In the charter, it's called the president of the council, and there are some functions that are accorded to the president of the council in terms of being the officer or being a member of the council, the head of the council, and the head of the city government for all ceremonial purposes. In terms of the manner in which the council acts, the charter requires that you act only by ordinance, resolution, or motion. You are a city manager form of government. It's a council member or a council manager form of government. And the city manager has been given under the charter the responsibility for all administrative matters. And so you can kind of see the pretty clear separation of powers that has been set out in the charter. You are responsible for legislation and key quasi-judicial decisions. The city manager is responsible for all administrative matters. As is very typical in home rule charters with a council manager form of government, there is a very explicit command that says no interference by the council or any of its members in administrative matters. That's very typical, and it really is an admonition by the citizens, again, a way of keeping faith with what they want by not interfering in administrative matters. The manager has ultimate authority over all personnel in the city except for the city attorney and judge. So your direct reports are three: the city manager, the city attorney, and the judge. And everybody else, authority over them has been delegated to one of those three individuals. The city attorney is addressed in the charter. The council appoints the city attorney, and the city attorney serves at the pleasure of the council. Again, that's pretty typical in home rule charters to have language that says that the attorney serves at the pleasure. The city attorney's role is to advise the council and city officials in legal matters. So in addition to charter requirements, the city attorney, like all attorneys, is bound by certain ethical rules that are found in the Colorado Rules of Professional Conduct. And so the charter, together with the rules of professional conduct, are kind of what set boundaries around the responsibilities of the city attorney. So how does the attorney-client relationship work in the municipal context? When we're thinking about attorneys and clients, where the client is an individual, that's a pretty obvious thing. But when the client is an organization, there may be different views about how that attorney-client relationship works. I know that currently the position is not quite yet settled, but this is one of those issues that you may want to explore with your city attorney further. I have a view about how I represent an organization, and I kind of tend to look for who is speaking on behalf of the organization on any given matter. That's who I'm working with. That's who I'm representing. It's kind of the simplistic way that I look at the attorney-client relationship in a municipal or organizational context. And Kirsten, I don't know if you have any additional thoughts or comments about that.
Well, from a litigation standpoint, I usually look to who's been delegated certain authority, and we're usually talking about upper-level management, certainly. So I try, to the extent I can, to deal with the manager, the city manager or his department heads, but below that, I usually want to ensure that that the department head or the manager is on board with what's going on before I'm going to render advice. That's a real practical position.
Yeah, I think that's good advice. And, when the person speaking for the organization is the council, then I see the client as the council, as opposed to any individual member of the council. Now, obviously, that doesn't mean communications can't happen with individual members, but when the council is the one doing the talking, then the client, I think, is the council as a whole.
And at some point in time, Tammy, just to pocket some of that somewhere is in some quasi-judicial roles, we have boards and commissions that will have either the city attorney or someone from the city attorney's office advising that board or commission. Then sometimes issues get elevated to the council. I don't know if this evening is one of those things for us to resolve some of that, but I would pocket some of that question is how do we deal with those where the city attorney's office is in multiple advisory roles, because you're going to have the organization is going to be different parts of or delegated elements of the organization.
Yeah, Kirsten, I don't know if you have any thoughts on that.
Well, I would like to hear your view, certainly. So we do, one of the things that I do tell boards and commissions is ultimately I can advise you to the extent you're not in conflict with my ultimate client being city council, and we do struggle with that from time to time. So if you have any practical thoughts, we'd certainly like to hear them.
Yeah, that's a very good question, and some interesting scenarios can potentially happen when you're advising boards and commissions that may not ultimately be following the same track as the council. My hope would be that disagreements would be along the lines of application of policy. And obviously, there, reasonable minds can differ as to, what an appropriate decision is, according to the view of the board or commission, as opposed to that of the council. And then I don't see a conflict there on the city attorney's part. If there is a dispute over jurisdictional issues, what authority does a board and commission or commission have versus what the council's view of what functions were delegated, then I would completely agree with Kirsten that, she has to represent who is speaking for the city, and who is speaking for the city in that instance ultimately would be the council, not the board or commission. But, in terms of the daily functions of boards and commissions, I typically do not see a conflict in advising a board or commission and then advising the council, other than those types of jurisdictional type disputes. Does that track with some of the concerns that may underlie your
I'll
question?
complicate it with a closer
A hypothetical?
We're looking forward, but experience is also one of those things
Sure.
that it's hard to separate from. We have a number of boards, commissions that operate on a quasi-judicial basis where they're making a judgment, and it may be within their scope to make that judgment, but at times an appeal can be made to the council, and we have several. It's not just one board or commission, or a recommendation is then brought to the council. Where there's someone from the city attorney's office advising both groups, possibly the same individual advising both groups. From your perspective, how is that best dealt with? Because a decision's been made, it's now being appealed, and you have advice being given to both, and that essentially at that point in time, it's a judicial process.
I guess I don't see a conflict from the attorney's perspective because the attorney's role is merely legal advice. And so, it may be that the board or commission and the council ultimately don't have the same perspective on the decision itself, but I guess in my view that doesn't necessarily create a conflict from the attorney's standpoint because it's merely a legal advice role. And so
in that instance where it's not just whether the attorney may feel whether there's a conflict or not, but there's the perception that can be there by a board or commission that their representation is compromised because there is a higher authority in some of that, and a perception that they may not be adequately, because you're going to have a difference of opinion being coming to the table. Would you suggest in those instances that the advisory role would be at least two different individuals from the city attorney's office, or otherwise?
Can I make it more specific? We did have one board where a decision that they made in a quasi-judicial hearing was appealed to the city council, and the board felt like they needed their own attorney to advocate their decision to city council.
Wow.
So can you comment on that?
Yeah, I can understand the discomfort. I can see where a board or commission might look cross-eyed at the attorney and say, you're just here to spout the party line, or that kind of level of discomfort. I can see that happening. If the advice is true to the underlying legal requirements on which the advice is given, then I think over time and the building of credibility, those concerns can go away. Having a different individual advise from within the city attorney's office might not be a bad idea. It's fairly commonplace to have, assistant city attorneys or deputy city attorneys advising boards and commissions for various reasons, among which are that, the city attorney can only spread himself or herself so thin in terms of evening meetings and the like. But, just in terms of a comfort level, it might be a good idea to have different faces at the board or commission level as opposed to the city council. The only area where there is truly a legal conflict is when a board or commission needs somebody that I'll call a prosecutor, for lack of a better word, and then also needs an advisor to advise it. Obviously, the same person can't do that. I would even have a question about, well, I suppose if you dedicated that person to being a prosecutor, and I use that word very loosely, it would be all right. But that would be the only area where you could have actually a conflict of interest, as I see it. Does that help address any of these issues?
Yes.
Okay. So the municipal judge, let's move on, and it was very interesting to hear the exchange of thoughts and the discussion among the council, the manager, and the judge. And I thought, wow, this is a really good example of the council dealing with its direct report in a very responsible fashion. So I really applaud that happening. And then administrative issues being the province of the city manager, I think that all really made a lot of sense. But your municipal judge is one of your few direct reports and is appointed for a 2-year term, may be removed at any time by a unanimous vote. I was kind of surprised to see that in the charter. Haven't seen that requirement in too many charters. I suspect it might be a substitute for removal for cause, that, we're not going to talk about cause, but there's got to be unanimity to remove a judge during the term of office. So that may be the origin of that particular charter provision.
Tammy, our 3 direct reports, the judge is the only one that has a 2-year term. Do the other municipalities that you're aware of have the 2-year term for the judge?
I don't know that there is a standard. I'm going to guess it's either a 2-year or a 4-year term.
And there are some municipal judges in the state that are elected by the citizens, and so that then would determine their term.
Yeah, good point. So the charge of the municipal court is to have jurisdiction over all charter and ordinance violations. And as a practical matter, that means ordinance violations, because people don't usually get written up or get tickets for charter violations. In terms of what are the regulatory boundaries around the municipal judge's office, interestingly, the Colorado Code of Judicial Conduct doesn't seem to directly apply, and the Colorado Rules of Judicial Discipline definitely do not apply to municipal judges. However, to the extent that, somebody holds a law license, then the Colorado Rules of Professional Conduct for attorneys could arguably apply. So, as I say, I kind of observe the relationship of the council to the judge, and if there are questions or thoughts about that issue, I'm more than happy to listen to the discussion and or answer questions.
Well, Tammy, just one is, at least my recollection, and I could be wrong in this, is our code, as far as the municipal judge is concerned, our municipal judge does not have to be an attorney.
And that's not completely atypical. I think for the most part in larger municipalities, attorneys are selected as judges, but you're right. Even in the state statutes, you don't have to be an attorney to be a municipal judge. I think it helps.
Yeah, there wasn't that was not a value judgment,
Right.
other than a statement that it's not in the charter, it's not
Right.
in the state. It's a preference that we may have.
Yeah, interesting. And in terms of the relationship of the city attorney to the municipal judge, they're separate offices. They've been delegated completely separate functions. There's kind of a basic separation of powers issue there. And so I would say that it's a cooperative relationship, and that the two offices may certainly intersect on administrative issues that concern both. But certainly one would not be responsible for the other, or vice versa.
Now, Tammy, are you aware of other jurisdictions that we have 3 direct reports, city attorney, municipal judge, and city manager, which is different than the way the federal approach works, because you have your attorney general as part of the executive branch. Is this typical for the city manager type of government in the state, or are there others where the city manager or the city attorney is incorporated in the city manager's office?
I think that there are some municipalities where the city attorney comes under the manager's office in a formal way, but I think that is relatively uncommon. In the charters with which I'm familiar, this sort of 3 direct reports to the council structure is the classic and the most common. Certainly, whatever the formal reporting requirements in the charter are, especially with respect to the city attorney, I think a successful city manager, city attorney team requires that they be on the same team. I don't think there's any doubt about that.
Isn't Denver's city attorney under the mayor's office?
I am not sure what the Denver approach is, but, I guess I would not turn to the Denver charter for
For guidance.
And I say that with all kinds of love to Denver. Denver's charter really is unique, I would say. And I'm not sure who appoints the city attorney. It may well be the mayor.
The mayor does,
Yeah.
I'm pretty sure.
Yeah. So boards and commissions are created by the council, according to your charter, and the members are appointed by the council as well. The functions of boards and commissions are basically what you decide those functions are by ordinance. They do have the ability to adopt their own rules of procedure, but obviously they need to be consistent with the charter and the creating ordinance. Very quickly on council rules of procedure.
Tammy, we have,
Yes.
yeah.
Oh,
On
sorry.
the housing authority, that's a little different critter than the rest of our boards here. Because I think a few weeks ago, I think someone had made the comment that the city council could be the authority board. But is that true in our case?
Under the state statute on housing authorities, it is correct that the city council could make itself the board of directors of the housing authority, but you're absolutely correct that that's a different type of creature, because that's actually a separate legal entity. So it can sue and be sued on its own, et cetera. So in that sense, it's a little different from your other types of boards and commissions. Absolutely.
Thank you.
So I was pleased to see that you've set out some pretty detailed procedures in your council rules of procedure, your rules of council, and they do cover a wide variety of procedural details in relation to things like meetings and public hearings and executive sessions, agenda setting, study sessions, motions, and so on and so forth. One question that commonly comes up is, well, what about Robert's Rules of Order? Should we be following those as the city council? And, you know, over the years, I've tried to understand and apply Robert's rules in the municipal setting. And my take on it, for whatever it's worth, is you've got some really well spelled out procedural rules in your own rules, and to try to engraft Robert's rules might not be workable. I've found that Robert's rules seem to be aimed at a different type of meeting than the types of meetings that councils have. And so, you know, if your rules of council are serving you well, then Robert's rules may really just add layers of confusion as opposed to clarity. So, yes.
Could you go back to bullet 2?
Yes.
The exec sessions? Because a lot of that's covered by state.
Yes, absolutely. I took a quick look at your rules of procedure in comparison to the state statute, and I think that they are very compatible with one another. As a home rule municipality, I think that there's at least an argument that you could set your own procedures, but I think that your procedures are consistent with the state open meetings law.
I'm actually going back to the issue before that one.
Sure.
Or more broadly. The city participates in a retirement plan. The city has a self-funded medical plan. Where is the fiduciary responsibility and liabilities for those plans?
Are they set up as trusts or?
No.
No, okay.
Can you elaborate on what you mean by trusts?
So they're just administered by a board?
Yeah, we have
Okay, of
internally.
employees?
I think that's just of employees, yes.
Okay, yeah. Some of the plans I've seen are set up as trust documents so that the governing individuals are the trustees of the trust.
Okay, that is the way ours is set up.
Okay. In that case, I think that the fiduciary liability would rest with the trustees. But, you know, the ultimate practical and possibly fiscal responsibility, you know, might rest with the city at large. So I'm certainly not suggesting that you can take a hands-off approach and not worry about it. I'm aware of instances, for example, where the trustees were really not on top of the types of contributions that were being made to the plan over the years, and then allegations that the plan was not properly funded came to the surface. And, you know, if a scenario like that were to come to pass, I don't think as the council you could say, well, that's the trustees' problem, because obviously that would be the city's problem. So, you know, while the legal liability might belong to the trustees, the greater responsibility would obviously be
Well,
the
with that,
city's.
Tammy, I'm not sure of this advisory relationship, though.
Yeah. with the trustees of
No,
your...
I'm talking with you. That's not the answer I look for.
Oh, well, I would defer to Kirsten, of course.
We can have more discussion on that, but we are moving towards ICMA's standard fund lineup, so with that, and we also have an outside pension attorney who advises us. I think we're in pretty good shape, but we can answer questions after this because it's not entirely relevant to this situation.
Yeah, I mean, where my question comes from is other organizations, there was at least from the governing group, our name would be for the council, is there would then be a representation from that group if indeed the ultimate responsibility ends up coming up to the city level as opposed to the trustees for further discussion.
Yeah, yeah.
Okay. Tammy, before you move off council rules of procedure, you may have noticed that in our rules that we're adopting, we want to have an evenness of information and make sure that if I'm sharing information with one member of City Council, that all members of City Council are getting that information, and same with the city manager. Now, we're struggling with where is substantive information and what is stuff that maybe that's overkill. But setting that aside, we now are running into the issue of having one main point of contact, and naturally that would make sense for that to be the mayor. But there's certain things like setting the agenda where the mayor is working with the manager, and maybe the information isn't that the mayor's receiving immediately is maybe not being received by everyone on council, and so we're kind of struggling with that balance. I know I didn't talk to you about this beforehand, so I'm kind of putting you on the spot, but I thought maybe with all your experience you could comment on how other jurisdictions handle that.
Yeah, I think there's a variety of approaches. One would be obviously to let your city manager set the agenda. Another would be pretty commonly that the manager and the mayor work together to set the agenda. But I've certainly worked with councils where the entire council wanted at least the council part of the agenda to be set with input from the entire council. So that can be workable as well. I worked in one municipality that used its workshops or study sessions to set its council agendas, not for the next meeting, but for the council meeting following the next meeting. And so it was pretty far ahead planning, because obviously, you can't, as the council, meet in study session this week and then expect the staff to be entirely prepared to address the issue on the official agenda the following week. So, I've seen this work in many kinds of ways, and if the council wants input into, the council business part of the agenda, then maybe the workshops could be used to set those agendas, a few weeks out as opposed to the next meeting out.
It seems to me that might be less efficient. Is that what?
Yeah, it's certainly less efficient, because obviously then the agenda is locked. At least a portion of the agenda is locked several weeks out in advance. And so, it could be that you'd want to allow the manager some discretion then to bring things onto the agenda without further council discussion. One of the issues that sometimes comes up is that one member may be extremely interested in an issue and it'll wind up on the agenda, and then the rest of the council is saying, what is this doing on the agenda? We have no interest in this issue. And so, that may underlie the rationale for greater council participation in what goes on an agenda in the first place. And there are different ways to work that issue, too. I had one city where the city attorney was not allowed to work on any issue unless there was a form turned in that was okayed by at least 2 council members. And
Someone's shaking their head no.
This happened in a city where I was, working on an hourly fee, and so obviously the more, wrong paths I ran down, the bigger the city's legal bill became, and so that might have been the reason why that happened. But there are certainly any number of ways to deal with agenda issues, and I'm not saying anyone is superior to another. Obviously, the fewer people involved, the more efficient the process is.
Well, and actually, in our rules and procedures, it says the agenda is set by the city manager.
Yeah.
Right. I think my point is more, and Tammy's covered it for me, and that is keeping the evenness of information. As you know, that we're kind of struggling with the whole balance of how we get, things happen quickly and a lot comes up in a day, and how we ensure that everybody on council is having access to the same information.
Yeah.
So I think you've covered that for me.
So let's turn now to open meetings issues, and we kind of started talking a little bit about executive sessions, but all local governments are covered by the statewide open meetings law, and so all meetings of a local public body or any board or commission of a local public body has to be open to the public and held only after full and timely public notice. Your rules also address executive sessions, as I say, in a manner, I think, consistent with the state open meetings law. So some of the common questions that arise under the open meetings law, it applies anytime 3 or more members of a body such as yourself show up in a particular place, and if you're discussing public business, then it needed to have been a properly convened public meeting. So if you show up in the same place together by chance or at a social gathering, then the requirements of the open meetings law don't apply, and so you don't have to give public notice that you might show up at local restaurant altogether, as long as you don't discuss public business. But I think appearances are kind of important where open meetings are concerned, and so if people see 3 or more of you having your heads together in any locale, then questions could arise, and so it is important to kind of stay aware about appearances. So the essence of open meetings laws is that the public has the right to be present whenever the council or 3 or more of you discuss public business. So, that's the law, and it's not that hard to violate the letter or the spirit of that law. Email is one of the newest ways in which the spirit of that law can be violated, and so it's one of those areas where I think everybody has to be really cautious about what is discussed in email. Obviously, if you're discussing substantive issues in email, then the public didn't have a right to listen in. And so that can be a problem from the standpoint of the public. And so, I would say that emails should be confined to procedural stuff. I kind of listened with interest to the Metro Chamber discussion, and there was some, email Michael if, and I thought, well, that's a good use of email, right? Because it was strictly procedural. I'm just, here to express my interest in, please schedule me for. That's pretty procedural. But if you were discussing something of substance by email, and it was, serial replies back and forth, then pretty soon it begins to look like a public meeting at which the public was not invited. And so really a lot of caution needs to be exercised around the content of what you discuss in emails. Your actions need to be by motion, resolution, or ordinance in a properly noticed public meeting. Consensus, what about the role of consensus in a meeting of a public body? If it's a minor, non-substantive matter, I think that the presiding officer could say something like, any objection if, right? And then a consensus is kind of formed around it. It's recorded in the minutes. And I think that's fine for minor matters that are not substantive, that don't require, some kind of formal action. Executive sessions. There's got to be a motion to go into executive session. And so I know this wouldn't be an issue in Littleton, but every once in a while I hear about executive sessions happening from study sessions, but these weren't convened as formal meetings, right? Is this convened as a special meeting? Study session. So you wouldn't go into executive session from here. Good, yeah. I've heard of that practice, and I would frown on that. Another common issue with executive sessions is, okay, you've got this laser-sharp motion as required by the open meetings law in terms of the purpose of the executive session, and then you guys all troop off to another room and start talking about that one subject, and then somebody kind of veers off into another subject. Is that okay? What would be the right way to deal with that other subject?
Bring it back out into the public.
Exactly. Bring it back out into the public. If it's a proper topic for an executive session, then do a second motion and then go back into executive session to discuss that second topic.
Just on that, is it possible to convene, I mean, we've done it, so what's your opinion on convening an executive session that's going to be possibly staged to cover more than one topic?
I think that's workable, as long as the motion encompasses all of them. And then I don't know what your practice is on recording executive sessions and whether you turn the recorder off for attorney-client discussions?
That's what we do.
Okay, yeah, that would be the only thing that you'd have to pretty carefully choreograph in that instance, so. Yes?
That we needed to do an exec, and our next meeting was a study session. But we published the agenda and included exec at the end, that we were going to go into an exec and based on this criteria. Is that acceptable? It's a study session, right?
Not if it's a study session, but what you could do is recess your meeting and then continue the meeting on the date of your next study session. And then you could continue that meeting, have a motion to hold an executive session, and then when you're completed with that portion of it, you could then adjourn the meeting and go into study session. So I think there's some room to maneuver. Would you agree, Kirsten, as long as you recess to another date?
I think that's fine, if our rules permit it.
Well, in the past, our study sessions have also been designated as a special session of the council.
Yes.
And so therefore, when it's a special session of the council, we felt we could do an executive session at the end of that. So getting back to what Debbie just asked about, if we need to have an executive session, our next one is a study session, and it's always been classified also as a special session.
Yes, special meeting, yes, absolutely.
And then we felt it was legal to go into an executive session.
Yeah, I wouldn't see a problem with that because it's a special meeting.
That's right. We're trying to move more towards study sessions and away from special meetings, but that practice is okay. I agree.
That's what we've done in the past.
That's right.
Yeah. So, executive sessions are recorded, and citizens do have the ability to petition for access to listen in. And if a judge listens in on that executive session tape and sees that there are, one or more flaws, then the judge could very well make those tapes public. And so you really want to behave in a way that you do not mind seeing your words, typed out on a transcript during an executive session. We had a CIRSA member, and I can talk about this a little bit because this was the subject of litigation and appellate court decisions, but there was some joke telling being done in executive session, and these jokes reflected very badly on the people who were telling them. And so, these guys forgot the admonition that their words could someday appear on a transcript. So I know that you will keep that in mind in your executive sessions. Attorney-client privilege matters in executive session. One thing that I have found about executive sessions is that sometimes they're a little bit leaky. In some municipalities, in fact, you can time by your watch when word about what was discussed in the executive session will end up on the street. And that's a concern to me, but it's a particular concern when attorney-client matters have been discussed in executive session, and then there's leakage about what was discussed. Because obviously it's a very serious purpose for which confidentiality was required, and that's why the matter was discussed in executive session with your attorney. And so, who has the ability to say, let's make public what we just discussed in executive session, and what would be the proper way to go about doing that? The whole council, exactly. Wouldn't it be by a motion to say, I move to waive the attorney-client privilege and discuss this matter in a public session? And so, if one member of the council says, I'm going to talk about this, then they skirted the appropriate rules for waiving attorney-client privilege, and so, that really does carry, I think, some serious concerns.
In that, leaving that decision to the entire council, though, Tammy, would that have to be a unanimous vote or just a majority vote?
I'm going to defer to Kirsten. I don't really see any particular vote requirement for that.
No.
No.
This would be bringing it to the public, but if there's a negative vote on that,
Right.
that would be something I'd be uncomfortable proceeding if there's any member that says this should probably not be discussed in public.
Yeah, I would hope that the occasion where you decide to waive attorney-client privilege is rare. I can't see a good reason for it in any, conceivable scenario. But I really just raise that as a contrast to the way in which the waiver usually happens, which is that one person goes out there and talks. So I'm certainly not recommending that you ordinarily engage in a waiver of your privilege.
We don't have anything in our rules that would show any sort of, for lack of a better word, punishment or admonition or whatever the case to give for a council person to do that. Or is it a matter of just working well together as a group and trust? And I mean, what would you do? What do other cities?
I remember many years ago there was a CIRSA, I don't remember if CIRSA actually accepted the defense of the case, but the rest of the council actually sued the council member who was talking out of school. Yeah. So, but, I would hope it doesn't come to that. I think it is about trust and the pact that you all have with one another to behave in a fashion that doesn't harm the city, that doesn't harm the confidences that have been discussed, et cetera. Certainly I've seen rules of procedure, maybe even charter provisions that talk about censures of one another by the council, but man, if you have to go there, then your relationship with one another has deteriorated to a pretty low point. Yes?
If you're saying the entire council has the right to the privilege and that an individual member who breaches confidentiality may be acting outside the scope of the authority, the use of the word may be acting outside, I guess I'm curious, when wouldn't they be acting outside? Sort of maybe your comment about the faith of a charter thing. How can you not be acting outside if you break privilege the entire council has the right to?
Yeah, I think you've caught me on some weasel wording. I think you're right. It's really not may.
Okay.
So, I can't stress enough the need to maintain confidentiality once you're out of the executive session. The law blesses executive sessions only in the first place for certain, very critical matters. And so if it was important enough to have a motion to go into executive session, then surely it is important enough to maintain that confidentiality once you're out. So we've talked a little bit about electronic communications already, but the interesting thing about stuff like email, is that they may be covered by both the Open Meetings Law and the Open Records Act. Intuitively, it doesn't make sense to say that email is covered by the Open Meetings Law, but if we kind of talk about a scenario where you guys are bouncing your comments, replies back and forth, almost in real time, pretty soon that does get to look like a meeting, right? And so I can understand the rationale of the legislature when they stated that emails may constitute a meeting. Certainly, emails are documents, electronic documents, and so if they concern city business, then they very likely are covered by the Open Records Act, and so people may make requests for them, and there's a very good chance that they will have to be divulged if they concern city business. So, also in connection with litigation, electronic discovery is now absolutely routine, and so emails will be requested, blog postings will be requested, Facebook postings will be requested, tweets will be requested, and so you can assume that anything you type on the computer could potentially be the subject of discovery in civil litigation, and it'll be blown up into an exhibit 5 feet high. So you really want to conduct yourselves electronically with that in mind, yes.
What about texting?
Texting, yes, absolutely. I didn't even think about that, but you're absolutely, and records of texts can be made available, so you got to be real careful about texting as well. Oops, what did I just do? So I think I've covered that. Open meetings, open records, potentially discovery requirements. I like this quote from Abraham Lincoln: "Men should utter nothing for which they would not willingly be responsible through time and eternity." And isn't that so true now in this electronic age, where nothing that's put out there can ever be completely deleted? So we are going to be responsible through time and eternity for anything that we type electronically, yes.
Can you talk a little bit about the issue of personal email account versus an official email account, and whether such a thing even exists, and that kind of thing?
Yeah, there's been some success by public officials in keeping stuff that was in their personal accounts private, but if you're using that as a way to skirt around legal requirements to discuss public business, then I suspect that wouldn't protect you adequately. I think it really has to do with the content of the discussion as opposed to the medium or the location of the discussion. So I just would not rely on saying that was my personal email if the content of the discussion really is public business. Kirsten, do you have any? Sorry.
I would agree entirely, and it looks like Michael has something to say on this.
I was just going to mention that as part of going to paperless, one of the things IS is going to be working with you all on is having all of our emails run through the city server for it. And so the basis for the ownership, or retention of those emails will be held by the city. You obviously will have your own email for it, but if you only use the city email address for that government communication, it's probably the best way to protect yourself personally. The judge may still say, I want to look at something else pursuant to what Tammy had referred to earlier, but if there's nothing there, it won't be released. It'll only be within the city's system. And we'll talk about this more when we talk about the technology as well, and the risks that you will play having both the personal work and the government on the same hard drive, if you will. But that's one of the reasons we are going to be providing you with a technology, a tool, so that you have that separation of personal and private, if you will. Or, I'm sorry, government and private.
Great. Let's talk a little bit about ethics issues. And the state statutes do address to some extent ethics issues, and I would commend the articles and publications of the Colorado Municipal League. if you have an interest in arming yourself with knowledge on the state statutes on ethics issues. I would say that the state statutes tend to be kind of a minimum in terms of ethical issues, which is why many communities, including Littleton, have established their own ethics codes. We also now have to deal with Amendment 41 to the Colorado Constitution, and please don't ask me anything about it. Really, there is a theme that runs through all ethics enactments. And so, if you kind of understand the theme, I think that goes a long way towards understanding any and all of these ethics enactments. So, it's about disclosure of any personal or private interest that you may have in a matter that you would otherwise be voting on, and not participating in that vote. Also not even participating in the discussion. So if you've got a conflict of interest in a matter, then the best advice is always leave the room while the matter is being discussed. I've had some pushback on that advice sometimes. A council member will say to me, I've still got my First Amendment rights as a citizen. I'm not going to vote, but why can't I be in the room? In fact, why can't I sign up as a citizen to speak? And I guess my answer is, once you put on that elected official hat, you can't just take it off when it's convenient to take it off. And so the better part of valor is to not participate and not give any appearance that you might be trying to pull strings from the back of the room even. So leave the room if you have a conflict of interest.
Tammy, just
Yes.
I think I'm okay with this, is just because a council member might have an awareness of some facts or considerations that have been given somewhere along the path, disclosing that they have been involved in a discussion or something like that where they don't have a conflict of interest, but they may have some pre-knowledge or pre-awareness, that by itself is not a conflict of interest, correct?
I think that's right. And this is kind of a point at which we got to separate between legislative versus quasi-judicial, because the concept of foreknowledge becomes more important when we're talking about quasi-judicial matters as opposed to legislative matters. And we'll cover that quasi-judicial in just a moment. But I think you're right that having information in and of itself it doesn't necessarily give rise to a conflict of interest. If you receive confidential information, though, as a city official, then obviously using or disclosing that information is a huge no-no. You were given that information for the purposes of the city, and so to use that for any other purpose would be impermissible. Gifts are a big issue, and your code does address it, I think, pretty well. Private business transactions with those who come under your jurisdiction are problematic. And, of course, actions that would benefit your own or somebody else's business or financial interests in a manner in which, the rest of the public would not be benefited would be a big problem. So I guess I'd like to try to marry up. Yes, I'm sorry, yes.
So ethically, in the third bullet, you also don't want to take actions that harm a business that in some way is involved, right?
Well, that's a very interesting take on it, and I would say that wouldn't necessarily fall under traditional conflict of interest rules unless you were saying that, I'm going to give one business a disadvantage so that another will have an advantage. That would clearly fall into...
Or to get back at them because of something they did.
Absolutely. I think the idea of retaliation is definitely a huge problem, not a conflict of interest problem necessarily, but I would say a major, major liability problem, because then we're dealing with things like people's constitutional rights. So, but we'll talk a little bit about that in a moment. So I want to marry these up to my sort of standard liability suggestions, and these are suggestions that I've developed from my work with municipal governing bodies, and they're really not aimed at anybody in Littleton. These really are standard suggestions that I make around the state. Which members are new to the council? Okay, yeah, so a couple of you are new to the council. I think you would agree with me that your role and your relationship to the city changed pretty dramatically when you took that office, because you went from being a citizen to a public official. You may have been an outsider to municipal government previously, but now you are the ultimate insiders. Over the course of your term of office, I think that you'll find your role and relationship on the council will continue to shift and change. At times, you're going to find yourselves continually on the wrong end of a vote, right? 6-1, 5-2. Other times, you'll find that you're voting with the majority, or the majority is voting with you, and that you've become kind of an opinion leader on the council. So, your relationship to one another will continue to change. You may have been a critic of the way things were being done, but now you are the representative of all that you might have once criticized. There might have been a single issue that piqued your interest in serving on the council, but now you're the all-issues decision maker. Another thing about the change of your roles was that you took an oath, right, at the time that you assumed your seats. You took an oath to uphold the Constitution, the laws, the charter, and ordinances of the city. And when you took that oath, I think you made certain commitments. Again, this concept of keeping faith with not only the charter, but all of the other laws that are encompassed in the oath. So basically, you took an oath to respect the boundaries and allocations of responsibility set out in the charter. You promised with that oath that you would stay within the parameters of your job description as set out in the charter. You made a commitment that you would follow constitutional requirements, that you would not willingly violate the Constitution. And so as it relates to things like quasi-judicial matters, that means that you made a commitment that you would follow procedural due process requirements and give applicants and others a fair hearing in quasi-judicial matters. And, not only was that part of your oath, but violating that oath really is a prescription for creating personal liability. Almost in a literal sense, you're now trustees or guardians or stewards of the assets and interests of the city, and the protection of those assets and interests is perhaps your single most important function now. I don't think it's any exaggeration to say that your role is analogous to that of a board of directors of a multi-billion-dollar corporation. And so the guiding principle always has to be, what is the right thing for the city? I talked about this shift in roles, and over the years I've seen some elected officials kind of continue to hold on to their prior roles. I was the outsider, I was the critic, I had a single issue that interested me, and that's what I'm going to bring to the table now that I'm elected. You can see how that would be very destructive in terms of a proper perspective to avoid liability, to look out for the best interests of the city. And so recognizing that change in roles really is critical to reducing the risk of liability. It's also critical to your success because nothing that is on your individual agendas can move forward without collaboration and consensus building. You only act as a unit, and so unless you've got a majority with you, your own agenda will really kind of remain unfulfilled. Yes?
On collaboration and consensus building, there could be if a council member has a specific issue that they're wanting to move through, then what is your view on that council member meeting with other council members, one-on-one outside of public meetings to build consensus.
Yeah. That makes me a little nervous. This idea of evenness of information, I think you kind of start chipping away at that if you start forming little coalitions with one another. It's one person, one vote on this council, right? And so I sort of understand this need and desire for evenness of information. In the quasi-judicial context, I would say that is absolutely wrong, okay? I would absolutely say you're creating a huge liability for yourself. You're, cutting applicants or others with a concern about a quasi-judicial matter out of proper, public information and public deliberations on the matter. So if it's quasi-judicial, I would say that kind of coalition building is absolutely wrong. In the legislative arena, maybe not so much. This is one of those areas where I don't have a good glimpse into what happens behind the scene between, two or more of you individual council members. But I guess I have a concern about two of you meeting serially, 2 by 2, and then eventually, everybody will have been covered, because, again, that looks like it violates at least the spirit of the open meetings law, too. So I'm going to have to look to you guys for more wisdom on this, because this is one of those areas where I just don't have the, behind-the-scenes view of what happens in reality among you guys. Am I being completely unrealistic to say that that kind of coalition building just bothers me?
Words of appearance of impropriety.
Yeah.
It's just the
Yeah. So I don't know if anybody else has any comments
Well,
about that.
I'll make a comment. I frankly don't have any qualms if I want to meet with another council person to get some advice about something. And it may be something that will eventually come before council, may not ever come before council. But it doesn't bother me to call up Debbie and say, can we have a cup of coffee? And she says, what do you want to talk about? And I said, X, Y, Z. And we get together and we talk about X, Y, Z, because I need some guidance or advice.
Yeah, and certainly, somebody might look to you as a mentor and say, Jim, I'd like to buy you a cup of coffee and bounce something off of you. I guess I don't have a problem with those kinds of things. Where it would start bothering me is if you were kind of trying to skirt the public process by talking 2 by 2, as opposed to doing the discussion openly in a public meeting. So, Kirsten, I don't know if you have any thoughts on this.
Well, we have been in a lot of discussions recently about this issue, and that's exactly what we've been discussing, is we really want that discussion to occur publicly to the extent it can, and discouraging the vote trading. Obviously, that's not a good practice, but information sharing, if one council member has more information on a certain subject matter, in fact, I think we would encourage that sort of thing.
Yeah. And I think you may be able to use your manager as that kind of resource, as, preparation. I heard one city manager call it choreography, and I think it was said in a very positive sense. I'd like to consult with the manager so that I can kind of understand the proper time, place, manner, and venue for raising this issue, so that we don't all look like fools on television, kind of thing. So, I don't know if you have any thoughts about that.
The clarification, to some extent, it's around intent,
Yeah.
right? And that's only something that you all know. What's the purpose? Because the sharing of information, I think, is absolutely appropriate and necessary. It's the context of my comment, I think,
Yeah.
where Tammy was starting, was on the coalition building and trying to have influence of the public debate outside the public arena, which is different than chatting and getting information about Dr. Cobb meeting or information on something you might be interested in.
I think the distinction is collaboration is possibly okay, because now you're information sharing, you're taking what might be something less than fully baked to something that might be a bit more mature. and allowing for that. Certainly, and I don't think you'd get any disagreement, is vote trading is not good. The part where it gets what I would say iffy a little bit is when collaboration moves to, and I'll say crosses the line into what I would call heavier lobbying. Mm-hmm. That's the part that becomes a little problematic in that, because most of that, I think, should be probably at a different level, more public. But it's certainly collaboration to take something from a germ of an idea to something that might be becoming more fully baked. And as much as staff is good and available for some of that, council to council also works as well.
Yeah, good discussion. So some sort of hardcore liability stuff. You got to stay within the scope of your authorized responsibilities in order to maximize your immunity protections, and you also have to stay away from what's called willful and wanton conduct under the Governmental Immunity Act. So in Colorado, we're really fortunate to have strong governmental immunity protections, but they apply when you're within the scope of your employment. That's the term that the Act uses, even for elected officials, and not acting willfully and wantonly. So again, we go back to your job description. The best way to stay within the course of your employment, your scope of authority, is to follow the limitations that are in your charter. Once you start crossing those lines, then you really are crossing some scary lines from a liability standpoint. Willful and wanton conduct is not just that you kind of departed from your job description a little bit, but that you did so in a really beyond reckless manner and injured somebody's legal rights and thereby caused damages to happen. So you want to avoid outside the scope and willful and wanton conduct at all expense, because those are the buzzwords that will cause you to lose your otherwise excellent governmental immunity protections. You can also lose your liability coverage protections this way. Your liability coverages through CIRSA apply when you're acting within the course and scope of your authority as elected officials. So if you're outside that scope, then it's possible you could be outside your coverage as well. So, that raises the possibility of personal liability, including punitive damages. And I used to think, well, I'm really just raising punitive damages as some kind of scare tactic, because I, so seldom saw punitive damages being awarded against elected officials. But I've got a little collection of cases in Colorado or in the 10th Circuit where punitive damages have been awarded against elected officials. And so it does happen from time to time. My favorite example is of an elected official who engaged in retaliation. Shortly after his election, he called all of his deputies in. This was a county sheriff, and he picked out a couple who had supported his opponent in the election, and he let them go. He fired them. Talk about retaliatory activity, right? That was a $150,000 award of punitive damages against him, because a jury definitely thought that he had retaliated. So, pretty scary. We had another scenario involving a CIRSA member where one member of the council on his own decided to express his disagreement with the council's selection of the local golf course contractor by defaming the contractor in the most colorful and nasty terms you could imagine. I had to award this guy points for creativity, but he got sued personally for defamation, for interference with contract, those kinds of allegations. And when he turned in his lawsuit to CIRSA, we read the allegations and said, none of these allegations bring you within coverage, so good luck with that lawsuit. So, that's the kind of news that we hate to give to elected officials. Believe me, the last thing we want to say to the decision makers for CIRSA membership is, thanks for the contribution, but we can't cover you in this case, right? You don't want that to happen, we don't want that to happen, but that kind of willful and wanton conduct may cause that to happen. So understanding your job description, I've probably harped on that enough, is really critical to maintaining your liability protections. If you can't trace something you did or you're about to do to some valid source of legal authority, then you really could be walking on risky ground from a liability standpoint. And along these lines, a few potential red flags. I think you would agree with me that as elected officials, you act primarily as a body, right? You convene in meetings, you discuss and vote on the matters that come before you. So anytime you do anything other than that, a red flag should go up. And in that regard, when you look at the charter, the only elected official who has some specific duties carved out for her is the mayor, the presiding officer. For the rest of the council, there is not a single responsibility that is, given to one council member alone. Would you agree with me, Kirsten? I haven't read the whole charter, but I've never seen a charter that reposed the responsibility in one member of the city council apart from the presiding officer. So,
No, I don't think that exists.
yeah. So that should tell you something about acting on your own. It's not authorized,
The one thing I would say, it's not acting on our own, but to the extent that there may be a constituent that brings forward an issue, bringing it to city staff as a conduit, sometimes advocate, to say, hey, there's a real question out here, or at least supporting some of that. Whether we consider that within our responsibility or not, I think Littleton, we do that.
Yeah, and I think being a conduit for your citizens is something that the citizens absolutely expect and is, absolutely appropriate, except perhaps in the quasi-judicial setting. And I'll talk about that again in a moment. But, as long as you're not disregarding the organizational structure of the city in serving as the conduit, that is to say, if somebody brings forward an issue to you in, your district or ward, and you say, I'm going to talk to the lieutenant in charge of, my ward, right, that would be a big no-no because you've jumped down a couple levels below your direct reports. And so you want to make sure that if you're going to be a conduit, that you go to your direct reports as the conduit as opposed to jumping down one or more levels. Yes?
But I guess I didn't want to, I wasn't going to piggyback what Phil was going, but I had another issue. So, if you're, Phil, are you, okay.
She didn't say absolutely no, and she said it could be reasonable expectation, so I'm fine.
I'm going to back up a little bit to couple of the examples you gave me. Here's, I guess, my concern. You guys are saying here, the front end of this thing, it says CIRS is a self-insurance pool, not an insurance company,
Yeah.
but a risk-sharing, quote-unquote, agency. But the examples you gave on willful and wanton, are pretty egregious. I guess it's my understanding that you could get into a situation where council takes a course of action or settles on a course of action, and then a court could find that that wasn't appropriate, notwithstanding a reasonable argument on the part of council to take a particular action.
Sure.
And to extend that further, then, if I understand you correctly, if the court comes back and basically says, well, you guys were quote-unquote acting outside the scope of your authority, ergo, we don't have to cover you guys from the standpoint of liability, which strikes me as an odd conclusion for an insurance pool to take. In other words, from your guys' perspective, I could absolutely get my head around, okay, we're going to cover you on this, and then boom, you're out of the pool because you're too big a risk. Or we can't make it up, or your premiums are going to go out of sight. But for you guys to basically say, we're not going to cover you, and you, individual council members are now on your own, via condios. That disturbs me,
Yeah,
and I don't quite understand it.
yeah.
So maybe can you help me understand why that's a good deal for us?
Yeah, I actually am really glad that you raised that, because we had that discussion a couple of years ago, and it didn't arise in the context of council members. It arose in the context of police officers, who, as you can imagine, are on the front lines of, allegations of outside the scope and willful and wanton conduct. And so, there was a time when we took a fairly strict line along the lines that you just described, that, if you were outside the scope of your employment, then you were outside the scope of your coverage, possibly. We would kind of let people know that up front and cause a great deal of consternation. So we actually changed the language in our policy a couple of years ago, and here's the way I see it shaking out. If all of the allegations have nothing to do with your work as a public official, then, right, it's logical that we wouldn't cover you, right? If you were just Joe Citizen saying nasty things about another citizen, then you wouldn't expect coverage, right?
That does not sound unreasonable.
Right.
But if we're acting as a body
Yeah.
collectively and a court finds against us, but we have a reasonable argument,
Yeah.
and the court finds against us, that's a different issue in my
It
opinion.
is. And so, we're not going to hang our hats on scope of employment. Our take on it is this, that if you blundered in the course of doing your job, that's what insurance is for, okay? If you were willful and wanton to the point where punitive damages were awarded against you, then we would follow Colorado law, which says punitive damages are not insurable in Colorado, and you would be on your own. But the bar for punitive damages is incredibly high. So you would have to be acting very, very badly to have punitive damages awarded against you. But a blunder versus beyond reckless action, that would be the dividing line from our standpoint at CIRSA.
That's somehow, I understand what you're saying, Tammy, and that also sounds very equitable to me, but that's actually communicated somewhere in a policy?
We have a coverage document, yes, absolutely. And what it talks about is willful and wanton taking you out of coverage. And I do have sort of a chapter 2 to the scenario I talked about with the council member. We did initially decline to defend him. The lawsuit was withdrawn and refiled, and similar allegations were made, but allegations were also made that brought the rest of the council and the city in. So we defended him, we defended the rest of the city, we settled the claim for a good 6-figure sum. He was out nothing. So, again, I think, very good question. It does, I think, show the way pools are different. We don't want to be out of touch with your expectations of coverage when they're reasonable, and mistakes made in the course of doing your jobs. Why should we rely on a technicality that says, your job description didn't strictly say this? But if you were advised not to do something, right, and there's good documentation that you were advised not to do something, and you said, advice be damned, I'm going to do it anyway, that might be a different scenario. So, does that set your mind at ease at all?
I appreciate that.
Okay, thanks. Yes.
Tammy, it's probably worth mentioning, although we're not directly responsible for all the employees, that's the same standard that you're going to apply to the snowplow operator or the public services operator on a crane or police officer or firefighter. It's going to be the same standard. And what's daunting is when an employee has a relationship with their supervisor and the city manager and the attorney, but suddenly the CIRSA attorneys are in evaluating the case, which is what happens. That's the process.
Yeah, and we always welcome the input of the city attorney, and we don't have a problem if the FOP were to say, we're going to assign another attorney. We will all cooperate, absolutely, and especially when you have an experienced litigator like Kirsten, it is a welcome thing to be able to partner up with the city attorney's office. So I guess we've really beat to death this idea of the job description. personal motives. We touched upon that a little bit. Personal motives really do always need to be scrutinized because acting on the basis of personal motives can get you in trouble. And this is the example that I use statewide. And one time I used this example and people started looking at me somewhat nervously because apparently this hypothetical was actually happening in this municipality. But, the example I use is that some high-level city personnel can draw flack upon themselves, right? They can become unpopular with the citizenry, and then you may have a push from your constituents. We want you to get rid of so-and-so, right? If you act on the basis of that kind of personal motive, are those citizens going to be there to back you up? Right, if they led you astray. And so acting on the basis of personal motivations always does need to be scrutinized. Now, there may be legitimate grounds for the concern. Certainly look into those. But, acting on the basis of personal motives can be risky. We've talked already about confidences. One thing I would suggest, if you don't have it already, is to use a standard script for executive session motions. Do you guys do that?
Pretty much, yes.
Yeah, good. Meetings we've already talked about. It is a liability suggestion because liabilities can arise from improperly conducted meetings. Quasi-judicial issues are one of those key areas where you really have to follow rules that seem somewhat unnatural at times to you and or to the citizens that you represent, but not following those rules can potentially be a constitutional violation, a procedural due process violation.
And just a footnote to that is, I'll restate a request, which is whenever we move to a quasi-judicial status, that we kind of put the sirens on and make sure that we have that awareness.
Okay.
Yeah, that's great. Kind of mentally put that black robe on when you're acting quasi-judicially. Continue to wear the black robe in the post office or the grocery store if it's controversial and the citizens want to talk to you about it, because they can get you in trouble by subjecting you to ex parte contacts. Yes?
At what point does it become quasi-judicial for us? So, for example, I had a conversation with someone regarding their land and that they want to do a zoning change on it. They hadn't applied for anything. They were just talking, So, at what point then, do I not talk to them?
Mm-hmm.
And should I not talk to them when they say zoning? Should I just, nothing had happened.
Yeah. Certainly if it's pending, that the application's been filed, then it is or will soon be before you, right? Or could be before you, and I don't think you would want to talk. When somebody just says, hey, I just want to mention, they may have an ulterior motive in mind, which is to try to get a little bit of buy-in, right, before the official process starts. So I would be real cautious even at that point. If a matter reasonably could come before you, at some point in the future, I think you would just defer to the staff and say, talk to the planning department, kind of thing. Because the one thing you don't want is for somebody to feel as though they'd obtained some kind of commitment from you, or that you sounded like you were in favor of it. And not only would that be improper, but somebody's going to feel let down by the conversation itself if they feel like they were trying to get something out of you, even at that early stage. So I would be real cautious about talking about anything having to do with site-specific development issues, rezonings. Are you guys the liquor authority, or do you? Okay, good, yeah. So probably land use matters are the primary thing that comes before you, and I would just be super cautious about it. I'm going to jump to my sort of do's and don'ts in terms of ex parte contacts. You know, if you're wearing that mental robe, then you will understand how ex parte contacts really compromise either the appearance or the reality of your integrity and fairness as a judge. So, you know, letting citizens talk to you or inviting citizens to talk to you, you know, if you become sort of an advocate of one side or another on a pending matter, then you've kind of stepped outside that judge role. Lobbying, absolutely improper on a pending quasi-judicial matter. You know, lobbying is okay in certain contexts, but we don't get to lobby judges, and so if you're wearing the mental black robe, you should not allow any kind of lobbying. Or, you know, somebody picks up the phone and says, can't attend the hearing, but I kind of want to tell you my perspective on this upcoming, you know, site-specific development plan. What should your answer be? Come to the meeting, tell us all, right? Or at least submit a letter, and it'll be submitted into the record so we can all know about it. Public statements. Oh, did you have a?
I was just going to say that I think, council, it would be helpful as we walk through these to also remember that our boards and commissions need to honor these in the quasi-judicial setting as well. So if they're calling you about cases before them, each one of these applies to them as well, so it will help train them to remember that these are things that they have to honor as well.
Yeah, and I'd be happy to come out for board and commission training on these issues too. Public statements, you know, people say things in the course of their campaigns sometimes that could come back to haunt them on a quasi-judicial matter. So, you know, when a judge is up for one of those confirmation hearings, aren't they just extraordinarily careful about not saying anything that could compromise their ability to participate in a, you know, later decision? I'm not saying you have to do that, because obviously the public expects you to communicate. They expect to understand, you know, the points of your campaign. But if you made it one of your campaign points that you were never going to allow you know, a certain type of big box retailer to come into the city limits, you know, over your dead body, would that happen? Then do you think you might have compromised at least the appearance of fairness if that particular retailer were to come to you with a site-specific development plan application, right? They might rightfully say, you know, you need to recuse yourself based upon all these public statements that you've made, and then you've shot yourself in the foot in terms of doing the very thing that you were elected to do, which was to, you know, make decisions on these important issues. So, did you have a question or comment? Okay. Ethics we've talked about. You know, we don't see a lot of ethical scandals at the local government level in Colorado. We're not like Chicago. Anybody from Chicago here?
That area.
Vote early and vote often.
Right. I think the president is from Chicago.
Yeah, that's right.
Well, you know, Illinois is the only state where you go from governor to wearing an orange jumpsuit. But enough said about that. You know, I think avoiding personal or private benefits from holding public office that the rest of the public is not entitled to is really the key to avoiding these kinds of ethical problems. Okay, two more and then we'll be done. Reducing your involvement in administrative matters. We've talked about the lines set by the charter. It's very clear. Administrative matters are, you know, the province of your city manager, and so you got to stay away from those administrative matters. You've got the gold standard of city government in Littleton, and that is the council manager format. And the more you involve yourself in administrative issues, the more you're undermining that format and really kind of wasting the resources that you've allocated to it. John Carver, the board governance guru, says that boards should develop a taste for the grand expanse of the big picture. I love that. So we've talked about that, enough said. You know, there certainly is a big picture view on even administrative matters that you can take. And so, you know, selecting your direct reports, the budget, those are proper ways in which you can establish priorities and the big picture on administrative matters. But once you get below that level, you could be venturing into somebody else's territory.
Tammy?
Yes.
On the previous one,
Yes.
I can see where the council would be involved in citywide goals. But I don't really see where we would be involved in departmental goals, because that's the city administrator's responsibility to oversee.
Yeah, that may be so. I think that could be revised. Departmental goals might really be under the province of the manager.
Right, where that, if you wanted to I'll take a thought at a hypothetical distinction, which is it may not be departmental goals, but it may be outcome measures.
Yes.
That can be taken into departmental goals, but it would be the outcome measures and the prioritization of that I think would be appropriate for the council.
Yeah, beautifully said. I'm going to steal those words.
But when we do budget, we are in some way at that lower level. Because we don't just say, here's $10 million, go spend it in any way you want.
Sure. But that's okay. You're entitled to adopt even the details of the budget. So.
We have to, but that doesn't necessarily mean we have to, Becky.
And really, this is a liability suggestion, because when you think about it, when was the last time you ever heard of a legislator being sued? Right? Because they have legislative immunity. And so do you when you're acting in a legislative capacity. I would say there are legislators that darn well should be sued, but they've got immunity, and so do you. Same thing when you're acting in a quasi-judicial capacity, right? Judges don't get sued for the act of judging. They've got judicial immunity. You will also enjoy quasi-judicial immunity when you're acting properly in that judge-like capacity. But there ain't no such thing as administrative immunity. I'm sorry, Michael. So, venture into administration, and you're venturing outside the areas of your best immunities.
So,
yes.
And not specifically on that piece of it, but citizens often contact us with something, they don't know who really to contact on staff, or they're having difficulty communicating what their thoughts are to somebody on staff. There's nothing wrong in facilitating that, is there?
Facilitating in what way?
Sharing their concern, not advocating, not saying do this, but this, citizen, forwarding an email, for example. Or maybe somebody does talk to you and say, I'm not sure somebody really understands what I was asking. And so you just help to translate.
Sure, yeah, and I think that's similar to the conduit idea that was discussed.
And if you're looking for a stronger term, it would be acting as an ombudsman, which is directing to the right source. Sherpa is another one, which is providing some leadership and direction. So you can they're all 3-cent words. Is that right, Michael?
That is.
Okay.
Inside jokes.
No, but that's great. And you say, here's who you probably ought to be talking to. Let me know if you don't hear back. I think that's as much as you need to do. Final suggestion is to use your powers wisely and humanely. You've heard that term city fathers, right? In the old days, we used to call municipal leaders the city fathers. Now we call you the ultimate parental authority figures of the community. But kind of the same concept, right?
I prefer Grand Poobah.
Even better. But, whether you realize it or not, that's the way that you are viewed. And in terms of staff, the staff revolves around you. You're kind of like the sun around which the staff revolves. That's the kind of power and perceived power that you hold in this community. And so that power has to be exercised in a wise and humane and courteous fashion. And I'm sure this is nothing that I need to say in Littleton, but there have been a few communities I've been to where that seemed to, really need to be said, because you know what rolls downhill. Whatever tone you're setting at the top is what's going to permeate your entire organization. And, in a worst case scenario, somebody gets mad enough to drive a bulldozer through your town. So. And with particular regard to council meetings, I'm sure this doesn't happen in Littleton, but this happened in some communities I represented, where each meeting was an opportunity to throw a different staff member under the bus. It seemed to be a sport, and it got pretty demoralizing. You know what I'm talking about, Michael, right? You've seen that probably. Certainly citizens have every right to raise concerns about the way the public's business is being done, but when the attacks get nasty and personal, it's kind of time to redirect them towards the issue and away from, the bashing of people. And the most demoralizing thing is when members of the body from the other side of the dais start joining in on the staff bashing. And again, I'm sure that would never happen in Littleton. So with that, I'm going to sum up. Always do keep in mind that you are the stewards of the city's best interests and assets. Stay within that job description. Act as we, not I. Observe best practices in meetings. Meet the highest ethical standards. And use your powers wisely and humanely. And with that, I'll stop, and I'm sure you're very relieved to hear that I'm done. So thank you all very much. You had some great questions, and I appreciate that.
That was excellent, Tammy. I think you covered everything. So thank you very much for joining us, and we will take you up on your offer to come back for boards and commissions. I think that would be a great idea.
Yeah.
Yeah, that follows the adage of be careful what you offer.
She also has offered to look at our charter, so we will also take her up on that.
Okay, we'll take a 5-minute break and return 5 till 8.
Throw them in, so I apologize.
Well, while we're waiting for that, why don't we, if council is okay with discussing quickly breakfast?
Oh, yep. And we have legislative rules.
I know, we still have to do the breakfast. Are we ready? Okay, we're ready. All right, we'll do your legislative rules first.
I didn't bring my breakfast last week.
I can have Marlene make copies of mine.
Well, I had my last 2 years with comments and so forth, so.
Maybe you do want to do breakfast?
Do we?
She's got to get hooked up.
Okay. Okay, so we'll touch on breakfast. Peggy doesn't have her list. Does everybody else have theirs? Nobody has theirs?
The current city council breakfast schedule you're talking about?
Yeah.
Yeah, yeah. Could you share?
Here. How many people are missing?
Yeah,
Could
but
you
I
guys share?
I don't have the two I wanted to look at, so.
Yeah, you have to share with Phil and Jim.
Sure, Bruce, I got one.
We can make some copies.
Actually, I may have 2 copies.
Well, I thought I had it somewhere in here.
That's it.
I have a second copy.
So I don't know if this is a different version. I don't have the 12, 13.
Marlene's making copies.
Okay. So I think as soon as Marlene gets back and everybody gets theirs, I think what we want to do is just firm it up so that we can get it on schedules and Marlene can start preparing for the invitations, et cetera.
Well, and just as a part of that, what we haven't gotten yet is the logic between the change between the current to proposed or suggestions, and what logic there may be in groups that have been added versus groups that have been eliminated. That's the part.
That is just a list. There was no, you guys,
Yeah,
take
we
out
will-
the separation and it's just a cumulative list of what do you want to do. So we're not, those were received proposals from council members.
Okay, and we can certainly have some discussion of that. Since it wasn't on the agenda, I didn't prep for it this time.
No, but
It's on the agenda.
on this, I mean, it's been on the agenda for the last 3 sessions, and we just keep moving it and moving it. Quite honestly, I really don't want to get deep in the weeds on this. I think we've got some no-brainers that we do, and then if we have some others, but we do not have to fill up every month with a council breakfast either. I mean, we can make them, we can do what we feel is important and get those scheduled in.
And don't we
Jim?
already have something scheduled for January?
We do have the
From last year.
sewer.
We have we have a carryover. I want to say it's large businesses and ACC maybe?
And car dealers and ACC, that's what I had on my agenda for breakfast meeting in January.
Or-
Was car dealers, large businesses, and ACC president and
That was February 16.
Yeah, I think
That's
that's February.
February.
January 19th is
So we
the
did
sewer.
January
Hold
and
on.
February already.
February
Joint
is,
meeting with Englewood on this.
yes, and then February we have, okay. So, I think the best way to do this, 2012 Council Breakfast Group suggestions, those are
I do have that.
suggestions that I believe we've all
You get your own?
contributed to.
It's still,
Current city council breakfast schedule. One suggestion I would have is that there are a number of these that are would naturally go well combined instead of separately. So we may look at doing some combination meetings. We have done that in the past. But that also helps us be able to cover a little bit more space at the same amount of time. We have combined the Arapahoe County Commissioners and the legislators before.
There is.
That was 2
Which-
years, that was 2 years ago, not this year. Or not 2011. In 2010, it was combined.
We actually did it in 2011. We met on July 21st with the state legislators and the commissioners. And that, of course, has to be timed around the legislators' time. And we've got it written on here, current council, state legislators, Arapahoe County commissioners, so we've got that on there. I guess the question would be, do you want to meet with the Arapahoe County commissioners separately, or is that going to be
No, 'cause
enough? Okay.
the commissioners and who again?
State legislators, it's about halfway down under current.
Yep.
So we would want to keep that one and take out the Arapahoe County commissioners. Large business and car dealers,
I'm sorry. I'm trying to keep up with you here. So Arapahoe County Commissioners, what's happening?
that goes away because we are combining them with state legislators and Arapahoe County commissioners, which is about halfway down.
Yeah, okay, so
Okay.
that first line that goes away.
Yeah. Large business and the car dealers, that's always a good one. Everybody okay keeping that in?
February 16.
And I don't know, Marlene, have you sent out you've not sent out any notification on that one yet?
No, I have not.
Okay.
The last
And-
one that we have scheduled is just the Tri-Cities, the 2 January, joint council in Tri-Cities, but no other groups.
The Tri-Cities is in February, right?
That's
No.
the 27th of January.
Oh, okay.
But Tri-Cities has always been a separate entity other than our third breakfast.
Yeah, we don't
Because
really
only
count
happens
it
once
as a
quarter,
breakfast.
Usually on a Friday.
Okay, yeah.
Can I make one suggestion on the state legislators and the county commissioners? Since we're going to have to wait probably until after the legislative session to be convenient for that, we may want to wait until after the election, and that way we can catch the new state legislators.
Yeah, I think we
Post-election.
definitely plan that according to the election and to their
Well,
availability.
that puts the third Thursday in November, which you normally don't have a breakfast because of Thanksgiving, and the third Thursday in December, which you normally don't have because of Christmas. So having it after the election in November this year, may not be very feasible.
It's just, Jim, we just recently met with the state legislators,
Right.
and once we wait after the legislative session, we're into the next session and meeting with them sometime before. We haven't talked about the issue of whether it's the third Thursday or not either, too.
Mayor, can we go line by line instead of bouncing all over here? Because I have no idea which one we're talking about when
Yeah.
we're talking about it.
Yeah, we're
I'd rather
trying to.
not bounce around.
Okay.
Well, could we see where we have multiples of the same? We've got large businesses as bullet 2. There are also
We
Just
have-
over halfway down, and
Okay,
then
let me-
also at the end.
if I may. We will go through it line by line, and on our current city council breakfast, these are ones that we have had. And if you want to keep it, then we'll make a decision to keep it. If we want to combine it with another one, or we want to get rid of it, we'll make that decision too.
Excellent.
We have had a meeting with large businesses and car dealers combined. And large businesses is large employers for the most part. Are we okay with keeping that one?
Yeah.
Okay.
I think it's a good combination.
Yes. We have in the past had a meeting with the Planning Commission. I would almost suggest that our time with the Planning Commission is probably better served in a study session as
I agree.
opposed to a breakfast.
I agree.
Okay? So we can cross that off. The Tri-Cities group is a Friday. We've already scheduled those, so we'll leave that as an okay. Littleton Public Schools, Board of Education. Do we want to continue to have a breakfast with them, and do we want it to just be with them? Or would it behoove us to combine it with someone else?
What would it be like if we combined them with the commissioners and the legislators? I mean, when you're talking about legislation, school legislation is critically important, and it's critically important to us that we keep very strong schools, and we need a strong relationship between the city council and the school board, and combining it with the legislators would make a lot of sense, seems like to me. It'd be a larger group for a breakfast, but it's still the political entities, because two of us are nonpartisan and two of them are partisan. And so it kind of gives a good balance there.
Just a different grouping, Jim, which is if we're going to be talking about education, and that is, we also met with Diana Doyle and the ACC. I would put all the education together, put ACC. Yes, I realize that they have some state legislative budget issues, but that would possibly hamper some of the other issues we might have with the state legislators, which are broader than just education.
I think that's a good suggestion too. ACC and LPS.
Without the legislators?
Without the legislators. Just leave the commissioners and the legislators, as we've already talked about, just leaving it alone.
So is everybody okay with combining LPS and ACC?
Yes.
Okay. Hudson Gardens Board?
What I would suggest is, with Hudson Gardens, is combining that with South Suburban. I know it's not entirely the same, but it's one grouping that owns the other, and I would see that as being a more efficient.
Is everybody okay with that?
Sure.
Okay. The South Metro Denver Realtors Association?
I thought we got some good information from them when they met with us before.
They also showed up at Manus. I mean, they were interested.
Right.
I mean, that was probably the biggest breakfast we had.
I guess I wonder if it might be appropriate to combine them with someone else and perhaps have fewer of the realtors show up. I mean, have them designate, 10
Well, they
instead
have
of
a
20.
leadership
No, I mean,
hierarchy.
it was their board that was
Yeah.
here mainly.
But
Right?
if they're...
Yeah, it was their board.
But it might be constructive. I know that one of the things that they continue to bring up is how they could do different partnerships. So, the realtors might actually be a good one to combine with the school board too, because that came up a lot when we talked to both of them,
But do we now,
which would be a huge.
do we now have the liaison to them,
To whom?
to the realtors?
No.
We were supposed, when I asked the last time, I was told we were creating a staff liaison.
Oh, a staff liaison?
Yes, a staff liaison to
don't-
them,
I
to
don't know
help
the answer to that.
facilitate discussions of the kinds of opportunities and so forth.
I can check and get back with you, but I don't know. You might want to think about, and Jerry, I'd ask you, do you want to have it tied with the Littleton Housing Authority, too.
With the realtors?
Yes.
Sure. That's good fit.
So do we want to, so the Littleton Housing Authority, that was a recommendation, do we want to, is everybody okay with that? Realtors and Housing Authority together? Okay.
Mayor, if I may, I think that your comment relative to the Planning Commission is valid for a lot of these as well, because there obviously may be a desire to have a study session with the Littleton Housing Authority on some issue that is tied to your goals and objectives or an action that you're thinking about separate. So I would hope that, and I assume that you guys aren't all thinking about this as your only point of contact, but obviously there's, now that we're really focusing on study sessions, there's an opportunity to bring them in anytime.
At some point in time, there will also be an interest in a study session with the Historic Preservation Board as they're looking at suggesting code.
That's
Yep.
different.
Yep.
Downtown Merchants, that's always a good meeting, and that's usually fairly well attended. Do we see any need to combine that?
I have a question. Is that Hoodlums, or is that a different entity? Different selection?
Well,
It's all the downtown.
It's,
a lot of them
It's
are
not
Hoodlum,
strictly
but
the Hoodlum. If we do invite several groups, it's not strictly the Hoodlum group, though.
but I think we had talked about inviting property owners also, and not just merchants.
That's why I was
Is that
thinking.
where you were?
Yeah, I wanted to see a wider spectrum.
Yeah.
Because Hoodlums could pack the whole room, but they're all are single interest.
property owners, and then I think some of the folks who do the development too, the Jonathan Bushes and stuff, who may be property owners.
So kind of combining that.
Yeah. That would
Okay.
be a good combination.
Yeah.
Downtown merchants and property owners. I would think also, if council would agree, that it might be an excellent opportunity to also invite at least the chair and the chair pro tem of the planning commission, and perhaps also the HP board, because bringing those groups together, they've got they got a dog in that fight too, and that might be just a good opportunity, at least for listening and learning. Okay. Large businesses, we do have one with large business and car dealers. Part of what we had talked about when we dissolved the Business Industry Affairs was that we wanted to maintain a more mano-a-mano relationship with some of these more influential businesses in the community, so we started having these breakfasts. And I guess I would ask that going forward on these breakfasts, that perhaps each of the council members could suggest maybe 5 businesses within their districts that they'd like to see represented, and that would be what builds the
35.
list, and then the at-large.
Not necessarily large, then, just businesses.
Yeah, I think we're going with the larger employers, Chris, but I think that, I think businesses of almost any, some of the new ones, some of the, we did have the folks from Alta, Aspen Grove in, and that did not seem to be very valuable. But, having Margie from Aspen Grove. Yes, very. Maybe having a couple of the new business people who've come to town, EVOO folks. We had an incredibly interesting.
I like your thought of a business breakfast by district invitation.
Okay.
And that, if we're looking for Kelly to help coordinate that, maybe she could work with each of the, districts to try and get a geographic distribution, and it doesn't have to be by size.
Is everybody cool with that?
That's fine,
Bruce?
Sam. Works for me.
I was just going to throw on top of that, I mean, I think at one point we had some of the folks that Margie was in on, and maybe it was council workshop where we had a handful of the folks that do the retail.
Shopping centers.
Yeah, the shopping centers, and, that may, some of the bigger ones or some of the more substantive players there may be just part of this one as well.
So I wonder, though, would we do better to have 4 meetings with businesses one district at a time. So we could look at concerns of different district business stuff.
I guess
Like
I would
in the-
say
In the
that
northeast.
it's
Maybe in the future.
healthier to have them all combined because they are really all part of the city and,
A fair amount of cross-pollination.
yeah,
And I don't think they necessarily talk to each other by district.
right. They don't even really
But they
live
have
by
some
district.
concerns by district. If we're going to ask the downtown merchants as a special group, and are we combining them with somebody and I forgot?
With the property owners downtown.
So that's property owners, but it's still just the business, downtown businesses. So why wouldn't we give that kind of attention to a few other parts of the city where maybe they need a lot more attention?
Because we're going to listen to the downtown merchants talk about parking, which we aren't going to have covered elsewhere.
Peggy, I support you on that idea. I would prefer to have by regions or by district.
I mean, I'm thinking in
It is
part,
different.
particularly from your district.
Northeast
which
quadrant is
has,
different, yeah. I would like that, because then we also have the Broadway Mineral Corridor. There's lots of businesses over there.
Either
Lots of
that
businesses.
or take a separate one on top of all these and do your area too.
As well as other areas. I'm not opposed to that at all.
So,
Well, we have the opportunity during our citizens forum for each of the council districts to invite those people to come make presentations, which has kind of been the format for at least half of them last year, was bringing in businesses within those council districts
well,
to
they
talk.
do that, but that's different from hearing issues. Like last year, for example, each year with downtown merchants, we hear specific issues. It's not a presentation promoting, it's issues that they're trying to deal with.
Well, go ahead, Jerry.
I was going to say, I like the idea of having the separate districts, because they're going to come to us with their own concerns. I know with the downtown group, it gets a lot of emphasis from the city, period. That's all there is to it. Other areas don't necessarily get that, and I would like to hear from them by district what their concerns are. I think that would be a
And
good,
with
that's a good recommendation.
particularly the multicultural population in a significant part of your district, we may hear some ways to try to increase multicultural business opportunities.
Different issues in District 2 than there are in District 1, and so on.
Is it really by district, or do you want to think about it more on a geographic basis?
More geographical.
Like think about invite businesses from Littleton Boulevard, the Broadway corridor as an example, Santa Fe, which...
Yeah, I think a regional type thing makes sense, and that's along the district type thing, I think, too.
Okay, just want to be clear on not drawing a strict boundary.
Hold on.
Sorry.
Okay, Peggy.
So, but if we do Broadway corridor, we come in a couple blocks west to pick up the people that are kind of part of that complex?
That might make sense. I mean,
Right.
there's some relationships there.
I guess I am not 100% on breaking it out that way. I think asking the 4 districts to have businesses within their districts and have them come to the large business is a step that we haven't taken before, and that will bring a diversity of businesses in. And last couple of times we've had these business meetings with these guys, there has been some very strong dynamic and some great relationship building that's happened because of the diversity of the businesses. We had a business in South Park that was able to do some work with Long Technologies. They would not have hooked up otherwise had we not had them in the same room. And so I think that there is, and maybe what we do is the large business car dealers group, maybe it's that large business that we bring in the 4, and then the next one we take turns and break out by a district. But I think getting them in the same room together from a diversity that they wouldn't have done before, and something in Aspen Grove, they've created relationships with other businesses outside of District 4 in creating a synergy based on, us putting them all in the same room together. So I think there's a real benefit to that, just like I see where you've got a benefit
It's
to
a
it. I just
benefit
don't
either
want
way.
to
Either
do.
way you go, it's going to benefit the businesses.
Okay, so let's see.
You have 12 set up right now, just letting you know, if we're only going to do it once a month.
I don't know what 12 you have.
12 breakfasts.
These top ones right here.
1, 2, 3, 4,
They're on
5,
the
6,
top.
7,
Well,
8.
we didn't get through
We
the
have
whole
eight.
list yet.
Let's finish off the list and go back and do that. Let's finish off.
Yeah,
the
we
list.
have
Thursday breakfast schedule.
Okay.
Okay, so what, on the large business, a show of hands for those who want to break it out specifically by regionalism?
Being quarter, for example, as opposed.
Yeah. So, show of hands to do a large business meeting for District 4, and then do one for District 1, and then do one for District 2.
And not necessarily boundaries. I mean, there's still, I think, a Broadway type thing and flowing over into that surrounding area. It doesn't necessarily have to be by district, as Michael was saying.
Yeah.
Versus doing a meeting and having 5 representative businesses from each district at one meeting. So it would be 4 meetings or a combination. And I don't know how we'd fit all 4 meetings in.
That's going to be an issue.
I would, I mean, if you want me, but let me just make the comment. I would prefer that we look at one meeting by district invitation, try and get a geographic diversity in the group. And if we want to do some corridor work or complex work, that's going to be something I wouldn't want to just squeeze into a breakfast meeting. That's my
Okay.
thought.
Okay, let's do a quick vote on this. Show of hands to do one meeting
One meeting when?
with the 4 districts represented. Okay.
Immaterial to me. What we
All
do.
right. So, I know, we've got to do this.
It's either way, yeah.
Okay, so, high school student leaders.
Yes, we should have that.
Yes.
We're taking out South Suburban?
South Suburban and move South Suburban Gardens
Oh,
Board.
yeah.
Neighborhood Watch, HOAs, LPC, AAA. I guess, we didn't have that one this year. Neighborhood Watch, HOAs, it's just
In the
been kind of a
past,
fading meeting.
yeah, the neighborhood watch and the HOAs, I think the previous 2 years when we did have it, we got pretty much nobody. But I don't think we've had the LPC,
The last one was all those combined. And
We
we had
had-
mostly the Alumni Association
Right,
attendance.
yeah.
Very few neighborhood watch, if any.
and there's some overlap, though, in that.
In
Many
that,
of the-
exactly.
Many of the LPCA folks
Right.
Just cross it
are
out.
also
Yeah.
neighborhood watch.
Okay, cross it off. Inglewood City Council,
Here's a suggestion that I have. We have south, east, and west in addition to Englewood, and at least as a consideration, I'll put out on the table that we invite some folks from Englewood, we invite some folks from Centennial, we invite some folks from the Metro District, and I don't know if there's a representation from South Jeffco, but we have possibly a neighborhood breakfast.
what will we talk about?
You sort of got the Tri-Cities. I mean, it doesn't pick up Centennial.
I
Or
think-
south,
The Tri-Cities have a specific purpose, too.
Yeah.
Santa Fe.
And Inglewood City Council, we meet with them over the sewer plant. And I'm not sure we need to have a separate meeting with them
I would agree.
about anything else.
And then,
Well, I'm seeing it as an opportunity to open some doors with Centennial, maybe, that haven't existed. We really did well with the Tri-Cities over the years, but Centennial's there now. I'm thinking maybe it's time to pull them in, or...
If you don't see a neighborhood group, I would suggest we do something with Centennial. We share a big border to the east, and we haven't really nurtured that relationship. And we share some things with the public LPS. There's a shared aspect with some of the fire protection that's there as well.
Bruce?
I was going to suggest that, the fire protection piece of it. I mean, if you want to combine Centennial, Highlands Ranch, and South Jeffco with the ranch and the district on the fire partner contract, there's a natural fit at some level between all of those entities.
Then that would be a fire contract partner meeting.
That's right.
Correct.
It could be both. I mean, there's, it certainly would be a fire protection meeting.
District.
But it might also then have attributes of Centennial or Jeffco or Highlands Ranch, just what's going on in those areas.
Who would we invite from Centennial?
Well, certainly council members from Centennial.
You have Rick Vorey, Kathy, and Keith.
Yeah.
Go
I
into
don't know.
1 and 2 districts. They're 1 and 2.
Jerry?
I would prefer to leave it just the city council, have that relationship, nurture that relationship. I mean, the fire one's a big one, of course, but I do think it would just turn into a fire discussion.
And we, if I may interject, we are planning a fire partners event to try to build the relationship between that on a separate level. It's not quite as grandiose, it's just with the contractual partners, but it's still, I think, gets the same intent.
Okay.
So do we want to do a breakfast with Centennial City Council?
Sure.
Show of hands.
That would just open up.
Breakfast with Centennial City Council.
We've tried that before,
Yeah, we
and the
did.
people who live, 20 miles east of I-25 is not really interested in coming to Littleton. They see no direct relationship like the council people who live next to Littleton do.
So what if would we just invite those districts that border Littleton?
Invite them all. Let them, they're welcome to come.
They may have an evenness of information.
Okay.
You could do that. You could do them, and then Douglas and Jeffco County Commissioners that border us.
Don Rozier.
Huh?
Don Rozier is the commissioner in the South Jeffco area.
Oh, okay. Yeah, I don't know him personally.
I guess we just need to keep in mind, I mean, what do we expect? We need some expectations from this. We need to have the right people in the room, to just, because we don't do a lot of cross-jurisdictional things with them anyway, and I don't know that this would
Okay,
be...
I would even say we could give some suggestions to staff to come up with an agenda on that. We share an interest in South Suburban with Centennial. We share an interest around Broadway.
I'm more thinking, I understand the Centennial relationships. I'm more thinking about the Jefferson County and we boundary Highlands Ranch. And
We've got a lot of people on the west side of the river who go to the Jeffco Library on Bowles Avenue. Just a lot of people over there go to there instead of going to Little. So if we do something with South Jeffco, not only inviting the commissioner from that district, but invite the library director from that library specifically, and maybe even the manager of Southwest Plaza.
The other thing you could do, I suppose, is I mean, other than there's contiguity, I'm not entirely sure. Unless they tell us they have an issue that we aren't aware of. I'm not saying it's a bad idea. I'm just not. I'm sort of curious too as to what exactly the issues might be.
I guess I feel as though we need to have a defined intent in order to be able to make it a beneficial meeting. These were really established, I think, so that groups who could have an audience with council. And the Centennial thing I see even more because we would like to get them to consider the Humane Society. We do have a relationship with them in terms of the fire district. I mean, there are some things that, in South Suburban, there's some park issues. So I can see that being more than anything. We may try it one year and see what happens. It doesn't have to be forever.
I guess the other, maybe the more direct relationship would theoretically be some of the sanitation districts in Jeffco. I mean, you got Pat Fitzgerald and some of those guys, but that's more of a business relationship.
What are we going to talk about?
Well, that's the problem.
It goes
Over breakfast?
Yeah.
Well, it's no different than going to breakfast at the plant. But I mean, that, at least there's more of a working relationship per se, so,
Well, and
just from a communication perspective. I'm not
Yeah.
advocating, I'm just throwing it out.
well, and we're really, I mean, we've got plenty to pick from. We don't really need to create any more.
Yeah, you haven't gone down to the 2012 list yet.
Right. So right now, do we want to do third large business dealers, ACC? We've already got two large business,
No,
and we already have ACC, so we'll
I
take
would
that
never
out.
have-
I've already crossed it out, and I'm using ink, so I'd rather.
All right,
We can
perfect.
decide on Centennial.
Yeah, we are going to do a centennial city council. We'll do a centennial, give it a go, and we'll see
Okay,
how,
all right.
because sometimes these things work once, and sometimes it's like, boy, that was good, we should do that again. Okay, let's quickly run through. Can we all agree to change this to the third Thursday so that it doesn't conflict with the regular
I mean,
Thursday?
from the third Thursday to something other?
Right. Sorry.
I think having a deadline to adjourn is beneficial.
Well, yeah, to still, because usually, I guess, well, city manager and Charlie usually have to leave like 10 minutes early.
I mean,
We're
the
okay.
benefit in going with something like the second or first Thursday would be, then we aren't as concerned, and we could have a breakfast in November and December.
What happens if the advisory committee pushes their meeting back 30 minutes?
Yeah.
And I agree with you that we have a hard deadline, but that's, our
I'm happy to
president
walk
of our
in.
council has the hard deadline responsibility, and I hear she's a pretty hard
Yeah,
taskmaster.
by the way, let's speed this along. Okay.
I second that
So,
motion. Yeah.
this has already taken 20 minutes longer
Yeah,
than it should.
for not making a motion, I would ask for consensus on the second Thursday.
Second Thursday?
Yeah.
Is that okay?
Everybody okay with second Thursday?
I don't care.
Okay.
Wait just a minute, I need to check.
I mean, I'm paying and waiting every
Calendar.
Thursday morning around
Meetings.
here. Jeez.
Okay, well, Jim's checking that. We had a suggestion for nonprofit organizations focused on Littleton, some specifically from Northeast neighborhood. I actually think this is a really good idea to get these nonprofits all in the same room, and there may be, when we get these businesses in the same room, and there just creates this, oh, we could call me.
And we have some bigger ones and small ones, like Mission Hills is one, and
Well, and that's the thing, we've got people like Mission Hills who keep begging, what can we do to help? We've got another business who's asking, what can we do to help? And,
I've got an idea for that, but not tonight.
okay, are you okay with the second,
I have a standing meeting the first Thursday and the second Thursday of every month,
a morning meeting?
morning meeting.
Do we want to move it to a different day than Thursday?
no.
Mind you, that
I
when we
would, I've
have,
already arranged my schedule.
I know.
mind
Yeah,
you,
Thursday.
that when we have, if you have it on a Wednesday, you're going to have council or a
Oh, yeah,
study
we'll have our
session
council hangover.
the night before, and if you're late, and then you got to be here back at 7 o'clock, that doesn't always work real well, so.
Monday, Tuesday, Wednesdays don't work. That's-
Okay, let's keep it the third Thursday, and
Can I make
those who
another
need to
suggestion?
leave,
Can we
leave.
do it the second Thursday and possibly look at November and December, recognizing we all don't make every one of them?
I don't care, you can do that if you want to, I just won't be here. But that's all right, I don't have to be here every time anyway.
It just gives us more.
Well, if we do November, then I suspect some people will already be gone, not necessarily on our council, but some people will already be gone for Thanksgiving.
I usually would leave that weekend before. I'm just saying,
Well, I think let's go through it and see if we have, if there's if it's necessary for us to do it, and in which case, then maybe that can just be, those can be floaters, and we put them in where it's appropriate. What about the nonprofits? Do you guys?
That's good.
Okay.
So are you just the nonprofits, or might we invite some businesses from that area too?
What area?
The Northeast neighborhood.
Well, the nonprofits will come from all over the community.
I know, but what I'm trying to do is to engage businesses, help in some additional ways. There are a couple in the Northeast neighborhood that do outreach the same way that that the nonprofits do. So,
Well, why don't we have staff work on putting together a list of that, and then once we get that list, if we have some ideas and suggestions, and Jerry, you'll be key on that.
And if anyone has ideas, I think on any of these, email us and we'll start the list.
And then again, planning commissioners at minimum of twice per year. Again, I think that should probably stay at a study session level. Is everybody cool with that? Dr. Cog, and other areas of Littleton interest?
I don't know why you would need that.
No, I think we're fair.
There's a report twice a month about Dr.
We're
Cog
well
activities.
represented. And if we have any questions for them, we can pass them through you, I don't think. Okay. Tri-County Health, to discuss initiatives centered on planning for healthy living.
I would take that to a study session if we're going to do something like that.
Okay.
And we have some other considerations around how do we deal with like our healthcare complex.
And the lady who's been primarily responsible for that is retiring in April 1st, I think she told me. And so it'd be a whole new person coming in after that time.
So maybe that'd be a good time to do a study session and an update, once she's in and settled with that person.
And the other thing that they're dealing with a lot right now is aging services, Tri-County Health.
Are we taking that out?
I think we're not going to do a breakfast, but I do think a study session, I think it would be valuable for that. Bruce?
Just sort of a curiosity question, sort of going back to the nonprofits. Where would you fit the Colorado School for the Blind? Would you put it under the nonprofits, or would you put it in with LPS and ACC?
LPS and ACC.
Is that
We adding
you want
that?
us to do that?
I
think that'd be great.
Yeah, I think there's a natural fit in there somewhere.
And it's center.
Huh?
Colorado
The Center.
Center for the Blind.
What did I say, school? Oh, okay, sorry.
I only say that because they've corrected me so many times. They've got me trained.
That'll work.
RTD, I say no.
I say no unless we need a specific thing for a study session.
And then we can call Canton. Okay.
And we did already move the downtown.
Yep, sorry. Downtown property owners and merchants, we've already got that in. Landowners and retailers located on South Broadway. Auto dealers on South Broadway. I mean, maybe it's worth having a South Broadway breakfast.
That gets into that corridor discussion you had
I think
earlier.
you got it covered.
Well, we could
Do I-
just, the whole South Broadway.
Yeah, if you wanted to, I mean, theoretically, you could invite them to the Centennial, City Council when it's all sort of contiguous.
I would rather leave Broadway as a
its
separate issue
own.
for us, because we have our own issues there.
Is that a breakfast, you guys? Do you want to put that on the list?
I think it's more of a study.
Do you want to do it as a study session?
Yeah.
Well, I think we all need to be educated on some of what the city has worked on before and what the issues are before we'd have a joint session. I don't know if there's an evenness of understanding for all of us to necessarily come to that first, and so there.
Maybe that goes in what we, like the parking lot,
Yeah.
where we have the ones we're doing and we have the ones we want to
Yep.
keep.
Yeah, I don't want to
Okay.
lose it, but I think.
Right. Okay.
That's-
Citywide shopping center owners,
So, wait, I'm sorry, what did we just do with those guys then? Those two?
they're going into we want to do something, we don't know what we want to do, let's keep it
on hold. If we
On
haven't gained
hold.
enough weight, we'll have breakfast with them. Is that the?
Yeah, breakfast or study session or something. Okay, citywide shopping center owners, I think they are getting integrated into the large business things.
And so many of those shopping center owners are not in-state. They
Yeah, they
are,
are, yeah.
they
But I mean,
are
property-
agencies,
No, they're
retirement
regions,
agencies.
But there's a lot of property managers that, like that one.
Property managers are different, but owners are
Reps,
not.
though.
Property managers are very different people altogether, let's face it.
Than landlords, no, I agree with that, but I mean, at least they understand the plans and the, directions of what they're trying to accomplish. So, but I think you get them covered on.
They're worth talking to, of course.
Well, and that would be something too on the large business thing as we're working that through. Okay, HP, probably not.
Well, that's going to be a
Probably
study,
more
that was, my
session.
suggestion would be, it would be a study session, their update on True Grit.
On the city, on the shopping centers?
No, that's on the HPC.
HP.
Did
Keep
property manager goers went away too?
Wait, what happened to shopping centers?
Property management owners, no, out.
That's all I wanted to know.
Okay.
Yeah, added to business. And then fire district board,
We are doing something.
yeah, that's
with
being
them.
handled
We
elsewhere.
got it handled.
Okay, cool.
Okay, so how many do we have?
Wait a minute, Historic Preservation Board goes to study.
Awesome.
Historic preservation study, fire district was what?
Goes away.
That's going to be handled differently.
Actually, I
That's
have
good.
9. I have 9.
I have 10. Gosh,
Somebody check her math.
large businesses, LPS,
You don't have a number under Tri-Cities.
Custom Gardens,
To
No,
Friday.
because we pulled it
It's
off.
not,
10, I've got 10.
It's 10.
state legislators.
Okay, 10 is good since November and December are weird.
Tri-Cities is not a breakfast, not a standard Thursday morning breakfast meeting. That's why it's not numbered.
Tri-Cities.
Council
Still
district
only-
businesses
9 plus
run by
Tri-Cities.
council.
Okay, awesome.
Student leaders.
Legislative rules.
I'm sure you have nothing on the legislative rules and are ready to move on.
Move to adopt.
Proposed legislative rules, we've got our edits.
Sure, I like to find it. Okay, where are we? Legislative rules.
Here, give her mine.
Good.
Let me bring up legislative.
You said so.
Jim,
I do have a couple of comments about the
It's 9.
proposed legislative rules,
okay,
but we probably need to wait till
We'll get
Wendy gets caught up with us here.
okay. We got the breakfast done, though.
That's progress. Good night, Paul.
That was progress.
Hi, Paul.
Break, so it's.
Don't count them.
We'll deal with that.
Okay, I read
Figure out the schedule. Okay.
I think you got.
All right.
Okay, so proposed legislative rules.
Can you make it
Jim,
a little better?
I'm on to page 6.
page 6.
Was there nothing before?
Blue a page.
Well, I do, but I got to read and figure out what I meant by it because my note's not making sense to me tonight. Under legislative versus quasi-judicial hearings, the sentence, the paragraph structure there talks about quasi-judicial, then legislator, then quasi-judicial, then legislative, then quasi-judicial. To me, if it were organized that all the sentences having to do with quasi-judicial were together, and then all the things having to do with the legislative were together, that would make better sense to me. But
Kirsten.
We can do that, no problem. We took this, I think Wendy actually posted it on the clerk's listserv, and we got some ideas and took from those, but that's no problem. And that makes sense to me also.
Okay.
As a teacher and editor, for people who don't know what you're meaning to begin with, it's probably better to take an issue and the two ways the issue's dealt with, the way it's here, as opposed to the total grouping. Either that or have a heading that are numbered so somebody could see the parallel sentences in two separate ways, the way you're saying, Jim.
yeah.
But it's like mothers do this, fathers do that in terms of eating. Mothers do this, fathers do that in terms of teaching you to drive the car, whatever. it's easier to have that pairing when you're really trying to learn something.
Okay.
Okay.
And I did figure out what the other thing was. It's on page 4.
Excuse me, what is okay? Are we leaving it?
You're going to solve the
No,
problem.
you're
Oh, I'm
fixing
going to
it.
solve the problem, okay.
Well,
I'll
it-
reorganize it.
I understand Peggy's point, which is sometimes there's a benefit in learning if you allow for the contrast. From a simple organizational perspective, we may want to put it together. Take a look at it. The intent is there.
Kirsten, you get to fix it.
I will fix it.
Fix it.
Jim?
I'm on page 4. Item number J, I think, or K. It's in red. It's just 2/3 vote, period.
And,
You just need to get sentence structure there.
well, no, if I,
We couldn't hear the tape from that
Yes,
evening,
and-
so we,
and I had edited the red line version, so we actually brought it back because we weren't sure what the intent was.
Okay.
So we just left it in there more as a placeholder and
On a motion
reminder.
to reconsider, did you decide on a 2/3 vote, that it would take a 2/3 vote to reconsider something?
I frankly don't remember.
Right, and we could not, the tape, we had trouble, it was cutting out on us, and so, anyway, so can you decide that issue?
Yeah, because you have it
All
for
right.
suspension, so, but we weren't sure if you wanted it for the reconsider.
So the question is, do we want to require a 2/3 vote on a reconsideration, a motion to reconsider?
Yeah.
Raise your hands if you,
Yeah, that's what we said, right?
2/3 vote on a motion to reconsider. Do you-
Isn't this a Robert's Rules question?
No.
No, that
We don't want no
was
stinking
the,
Robert rules.
Thank you.
I mean,
we're making our own rules.
I know, but we did.
Robert who?
Okay, now that, just, I'll do the hypothetical on this, because I'm with Jim a little bit, and I can't remember. If a motion is brought to reconsider, is it 2/3 of the seats? Is it 2/3 of the present? So that something can come back if there's a different set of people in the seats. You can do a reconsideration that might only require 4 of 6, whereas 5 of 7 seats would be there. And that's kind of the practical side of it. I don't know what the answer should be. Is that what we want, is 2/3 of those present?
Yes.
I have nothing in my notes about that. I remember the discussion.
Bruce?
The last sentence, maybe I'm getting tired. The last sentence says a majority, that was part of what you guys heard on the tape?
No, that is not.
Okay, so what's that mean?
Because it's a contradiction.
Right.
Yes.
We had in our notes 2/3, and that was from an earlier revision. I think let's just maybe revisit the issue and decide, do you want to do 2/3, and is it a 2/3 of present or the whole 7? Keep in mind your rules.
Right.
What do you want to do?
And
Well-
I would just say, I'm comfortable with the majority of vote of those present for reconsideration.
I am too.
Okay. So a 2/3 majority of those present,
No, just majority.
Just
No,
a
I'm saying a majority of those
2/3
present.
of the council.
No,
No.
a majority of those present.
Oh, a majority of those present, okay.
Scratch
Which is
the
regular.
red words that were there in,
A motion to reconsider a proposal that has been acted
Yep.
upon must be made prior to the adjournment. A majority vote
Of
Okay.
those-
of council present, or of members present.
So it's just a simple majority.
Okay.
Okay.
That's Robert's rules.
Every,
Oh, let's go back to page 3 now.
But we're not following those.
well, sometimes we
Put 'em
do,
away.
accidentally.
Put them away.
Okay. Jim, did you have any?
Don't have anything else.
The end of that red 2/3 vote is.
The 2/3 vote we talked about on the previous
I just
discussion.
wanted to
Cross out the
It
is.
is.
delete the word is so it doesn't show up.
I'm sorry, I didn't know where you are.
See where it says 2/3 vote?
whether,
2/3 vote, oh, sorry.
There you go.
Bruce, would you leave that for Peggy?
I think she should have all of them. All the time.
Okay, Jim, did you have anything else?
Did not.
Okay, did anybody else have anything? Peggy?
Yeah, I have a few things, please. On page 2, 3B,
Didn't say anything. 3B.
the temporary chair. Whoops, were you hearing me, Jim?
Yeah.
Okay. In case of the absence of the mayor, it says, the city clerk shall do such and such. Well, you have to have the absence of the mayor and the mayor pro tem before the city clerk's going to call the meeting to order, as opposed to the mayor pro tem calling the meeting to order. Is that,
I looked at that same thing, and then I went back in to see if there was some place in there that said that the mayor pro tem automatically is going to succeed to that chair position, and it's not in there, but I just assumed that everybody would know that would be the case.
well, but in this particular sentence, I think
Add it in there.
it makes it a little tricky.
Add it.
So what was crossed out should be uncrossed out, correct?
Well, it should be, no,
Mayor or mayor pro tem.
mayor
Well, it'd be
and,
and/or,
and,
and.
and
Yeah.
mayor pro tem.
And.
Yeah.
And mayor pro tem.
Presiding
Okay.
officer, if it's a board or commission.
Well, we've defined that
No,
someplace
just
else. We defined
in the case of
presiding
the
officer.
absence of the mayor and mayor pro tem. That's
Yes,
it.
that does it.
Okay.
So we got that one. Just a second.
Let's start from scratch.
Letting your cynical side show.
Hey, don't you have somewhere to go?
And then I think in A, what you all are saying there, the mayor shall call the meeting to order. That one would be where the mayor pro tem would then
Right,
automatically kick in there, okay?
right.
Then on page 3, parliamentary rules, first paragraph, that's item 4, as a guiding principle. I think if you have a principle, and it's just guiding, that the may should be a will. It's just a guiding thing. So as a guiding principle, the following procedure will be observed. And it's still guiding, so you don't have to do it.
Kirsten?
That's fine with me. It doesn't really change the intent to me, so that's fine.
Cool.
All right.
And then would that be at regular and special meetings? Or did we say we were doing something entirely more freelance at special meetings? I know we're doing more casual at study sessions.
I put special up there originally, and I was told to cross it out, so I took it out. When we had this, because I made that
We
change.
told you that before?
Yes.
Well, we can be crazy ourselves, so.
All righty then, I can put it back
But,
in.
I mean, since a special meeting is essentially a regular meeting at a
Special time.
at a special time, it seems to me we would want to have the same procedure.
Kirsten?
That's a good idea, I think.
Okay.
I do remember you specifically taking it out.
Versus study session type thing.
Yes, and I can't recall why, but I think it's a good idea.
Okay.
And then A, under that, we have addressing chair, but then the first sentence says the presiding officer. And I don't know if we want to be just saying addressing mayor, addressing whatever, but it seems to me we're jumping around with our terms.
Change presiding officer to mayor.
Hey, Mayor.
And addressing mayor and change both of those to mayor then. Addressing mayor and then shall address the mayor.
Peggy, just to kind of, I'll nit on the nit. What happens when the mayor is not, and the mayor pro tem is not present? There is a presiding officer that may neither be the mayor nor the mayor pro tem.
Well, then that's taken care of in our opening that says these terms are interchangeable for that term as appropriate or something.
No, what happens if neither one of them is present? Then the presiding officer could be Councilmember Cole.
Yeah,
I like presiding officer.
but that becomes the presiding officer under a particular set of circumstances.
At the front end, it
And-
will be interchangeable with chair, vice chair, or other presiding officer.
And there may
think
be,
you get my point,
Kirsten,
but so I
some
won't
other
belabor it.
places in this that you would read through to see if we've done something similar to that, but anyway, did we do that one,
So the mayor,
The intent
presiding
there.
officer.
or are we still discussing it?
I'm okay with it.
Okay, so changing, addressing chair to mayor and presiding officer to mayor. I get what Phil's saying. Do we want to, I mean, honestly, whether you're the mayor pro tem, or presiding officer, you are that presiding officer at that meeting. That neutralizes all those terms if you just change it to presiding officer.
Well, and if we do that, I would argue we ought to do that in every place in here.
If I may, I think the intent, and I understand Phil's concern, but I think what Peggy had asked for last time and the council had agreed to was the front end paragraph. So if you go back to IB, it says, where applicable throughout this document, references, and I'm going to skip the part with city council, but references to mayor or mayor pro tem will be interchangeable with chair, vice chair, or other presiding officer of any board, commission, or committee. So I think the intent was, when Kirsten put this together, is that you could use the word mayor, and it will mean all the way down the food chain.
Yeah.
Is that, did
No.
I get your intent? No.
No.
Then please
Presiding officer.
try again.
What? Okay.
I'm
So,
missing it.
let's just talk about the council. Okay?
Happy to.
And we have a situation where the mayor's not present and the mayor pro tem is not present. Are we to use the title of mayor for the presiding officer at that point in time? I did not see that in that earlier paragraph intent, that then that third level presiding individual who happens to be the presiding officer gets the title of mayor or mayor pro tem.
What's wrong with Madam Chairman?
Yeah, and I don't think that's
I don't
certainly...
like being called madam.
Hey, hey,
That's your prerogative. Sure.
all right,
Presiding
come on,
officer
I know
works.
it's late.
That's why I like presiding officer.
Yeah, I agree.
But if we're dealing with 4A, if I may, it's addressing the chair, right? So you're addressing the mayor, which by the earlier definition can be a presiding officer.
No, I'm saying the chair of a meeting, when the mayor is not present and the mayor pro tem is not present.
Talking about the title of the paragraph.
I'm not talking about the, you can put that, I'm not talking about the title of the paragraph. I'm talking about line 2, which says presiding officer.
Yes.
Okay? You have an instance where a council member, okay, because you have a quorum, that's presumed, okay, who is neither the mayor nor the mayor pro tem becomes the presiding officer. Do they get the title of mayor in that instance, or is it council member Cole?
It's Councilmember
It's
Cole.
presiding
Right,
officer.
and that's
Chair.
why, that's why I'm saying it should be presiding officer.
I think that we should leave this one addressing the chair,
I agree.
because you're right. I mean, you're not going to step into the shoes of being called or
Well, then
referred
have
to as the
chair,
mayor.
have chair in both places.
Yes,
I raised
chair
this
and-
issue because we had two
Well-
different words in the...
Okay,
Okay.
addressing the presiding officer would be fine also. Let's
Yeah.
not change it to mayor, though.
That-
Presiding officer we use in the beginning in the definitions, and that is what I think we should use
Okay.
here.
So
I
shall
just-
we leave it as is,
Yeah.
Kirsten? Okay,
Right now, Wendy has it right.
okay. So it stays as is. Okay. Bring around the Rosie on that one.
Okay, page 4. When we have a point of order, Robert's Rules has a specific way of saying how the motion, if you are challenging the chair, presiding officer, or whoever,
Which paragraph, Peggy?
I'm sorry, oh, next to the last paragraph
Thank you.
there. You can raise the point of order, and if you want to appeal the ruling of the mayor, chair, or whoever, you get to do it. But there is a specific way that you get to do it, And the way this is phrased about the no votes, whatever, is not clear what the motion would be. I think, I'm trying to remember, Bruce, you had the book, but I think Robert's rule says something like, I move that the ruling of the chair be reversed or something like
Be
that.
reconsidered.
I can't remember how it's worded. Well, if you move it that way, then it should be the ayes that win. The other way to phrase it is, I move that, and it doesn't sound like you'd say you move to uphold the ruling of the chair. So I think it's,
Before we go further.
Do you want to put in here what the motion would be? Is that what you're saying?
yes, so that we wind up, if we want to have no votes, somebody knows how to phrase that motion.
Okay. Are you,
Should be the majority of original motion, no votes is necessary to reverse the
But I don't think that's the way it's dealt with typically, so
But
give him a chance to, whatever it is, I think it'd be good in this case to have the way the motion is stated.
okay. Well, I can add that. Can I add that and we can move on?
We'll
Okay.
have Kirsten
That's
add
good.
that.
You're putting it in favor of voting for no.
Just
Well, let's clarify that.
So the motion in here is, shall the decision of the chair be sustained? Or that's the question, I guess. Like, maybe the mayor asked that, I don't know. But anyway,
Okay,
that's
let's let
fine
Chris-
with me, that's fine.
Okay.
Well, we do need some clarification, though. Is that you want it to be you're voting in favor, you're voting against
In
the
favor.
motion? That's what you need to decide, is it?
Voting in favor
is-
of the chair's rule.
Okay. So will you put a note in there, voting in favor of the chair's ruling? Thank you.
That would be a majority vote in the negative to overturn the chair's rule.
Okay.
Yeah,
That's
so-
what
so
everybody
that
wants.
was-
Okay.
You're voting in
Shall it
favor
be
of a no.
sustained? Pardon?
It actually doesn't.
I followed you.
Yeah. We do it every November.
And I have one more, but let me see if I can get my brain to see what it says.
I'm trying to find my...
Oh, and we had this even in the presentation tonight. On page 6, V, near the top, at the top. This was one that was in the presentation tonight, that the council appoints the committees and so forth, and I think that we should be doing that here, just as we ratify the liaisons, or whatever we're going to wind up calling them, that when we appoint to special committees and so forth, that we should ratify, just as we did, well, and we appointed, either ratify or we appoint, just as we did to the Open Space Task Force and the Council Liaison Task Force.
So after citizens shall be ratified by council on the last sentence. The
Yeah,
mayor
just
may
the same way it is earlier. The mayor shall appoint board and commission liaisons and the chair of any special committees, and such appointments shall be ratified by the council. The same then would get put into the next sentence, so...
Which shall be ratified by council. You're saying right now it would say which shall be ratified by council, right thereafter, yes, I think. That's what
Yeah,
you're saying.
Yeah.
Okay.
Okay, everybody okay with that? Sure. Okay, do you have anything
We
else?
could move it
No,
around.
thank you.
Okay, does anybody else have anything else?
Jim's still thinking about that last.
It's basically saying the mayor can't do it exclusive of council ratifying.
For regular appointments and special.
Okay.
Okay, we're good?
Yes.
Cool. Okay.
So this will come back for you, to you for adoption on the the 17th, next Tuesday.
Okay.
Perfect.
Excellent.
Okay, so we're saving?
And I get Phil's proxy, right?
No.
You have to
Did you
modify
read the rules?
I'm going to call him in.
We have a remedial council university.
You'll have to be coming back for remedial.
Where
Okay, so
Goals.
proposed council goals and objectives. Michael, do you want to?
Yeah, I did, Wendy's bringing it up. I just want to real quickly, and maybe the mayor wants to walk you through what you have, but we continue to receive some comments. It was a relatively quick turnaround, as you guys know, and so we've got, when it comes up, you'll see there's some additional red lines on there from the version that you have there. So I just, we need to make sure we're referring back to the red line version, and you guys are comfortable with what's there.
You just said there's something different from what we've got.
Correct. That is.
Just let us know what it
Yeah.
is when we get there.
Yeah, there's not much, but there's just some, I was receiving emails, and that's, because of the holiday, it was just a quick turnaround for folks, I think, in terms of trying to get comments back.
So 11012 is not necessarily the most recent.
I would work from it, Jerry, but we'll have Wendy make
The
sure
red
that she
lines from
identified.
that. Right.
Yep, because there's not much that's changed.
Gotcha.
I do like this version, though, where it just lists objectives, because there's all kinds of action things or strategies you can do under each of these, which would go on forever and forever.
Yeah.
And staff can figure out how to achieve the objective without having everything listed.
Yep.
And did you?
I was just going to say, if you can get done tonight, that would be awesome. I'm not being facetious. It's just, this is, this document is yours. It's, you can, all of these, of course, you can modify it. But we will, and I mentioned this to the mayor, that if you guys are comfortable with generally what's here, if you can, I know it's 10 after 9, but if there are some high-level ones, or some, no, I shouldn't say high-level, but ones that you are really passionate about, that, and I think I've said this before, but we will move that into the February 10th meeting and really hone down in those areas that you've identified that you're have concern or high value around. And the example I've given you is the Northeast neighborhood. There's a lot of different goals in here that address that. So, and Chris is still here, and so he and his staff are working on putting together an in-depth presentation for you.
So
If I, hold on just a second, if you don't mind, Council, no, that's fine. I wanted to just kind of give a little caveat or a little brief on this. This is different than we've had in the past, and one of the purposes for this is also as a guiding document as the staff enters into budget too, because this gives staff kind of a clear definition of what council's goals are over the next couple of years. And so as budgets are being designed and developed, this will be a guiding document for that. So I think as much as this is intended to also help guide and direct us in our next 2 years, staff will probably use this even more. There's a lot of stuff. As I read through this, I felt like there was a lot in here that, to me, was, for lack of a better term, duh. It's part of what our job is. It's part of what we are here to do. And some of it is not stuff that's as much actionable that we can actually put task against it, as much as it may be as something comes in, it's a guiding document as decisions have to be made against certain issues. So going into the workshop, what we wanted to do was to really pull down into maybe 4, max 5 really big issues that will probably run through or touch each of these goals at some level. Michael mentioned the Northeast neighborhood. There's a lot of stuff there. That there's the safety, there's the housing, there's the businesses, there's Parks and Recreation and all of those things. And that can be a whole topic of conversation. Then I think another topic that is going to become more important and something that's pretty big picture and long-term, and will probably extend past the 2-year plan we have here, is the fire services. So, because we do have the trail mark issue, and I think we want to take a look at some opportunities beyond where we are now. So there's some stuff that we can vet out there. There's also some things regarding, there's some monies available now for us to do some pretty massive planning as it relates to our parks and trails, and particularly South Platte Park. That money will not always be there, so we need to make some decisions about directing towards that. So just throwing those things out, but those are kind of, and I'm sure that everybody has some others, but just trying to cull out of this for staff maybe 4 or 5 things that over the next month they can work on getting us some strong study material, so that when we head into workshop, we'll be able to start some balls rolling on some of those issues too. So, Jerry, Bruce.
With all that being said, I prefer under number 2, which is the police. We have in there provide police protection and service that meets the needs of the community. I really do believe we need to put focus on the northeast quadrant. It's, when I look at the police case reports, the trend is that the reports are going down. So that tells me that maybe we're not focusing on that area. And yeah, it looks great. We can say the numbers have gone down in that area. Then I look at the court cases. I see the court cases have gone down. And yet, when you go to that neighborhood and you talk to the folks over there, those folks certainly don't have the impression that crime and other things are going down in that neighborhood. Littleton needs to focus on that northeast quadrant. It is not getting it, and just to say provide it for the city doesn't cut it for me. And I would hope that I can get the rest of the city council members to support me on this, because we need to focus on that northeast quadrant. And again, when I look at the report, the numbers look great. They're going down. I had requested this report about 6 weeks ago. If I requested the same report with Denver, it would take me 10 days. So there's something's going on that I can't get this information in a timely manner. I believe that we're not focusing on it. We need to work on the northeast quadrant.
Bruce?
Not what I was originally going to say, but to support Jerry, would it make sense to have a study session to deal with how to scope out the issues that Jerry's talking about, the multidisciplinary response and everything, the parks issue, the rehab of homes.
And that's exactly what we've got planned for a 2-hour block on February 10th. That's in there. But if I may make a suggestion for a sentence modification. So if we said, provide police protection and services that meets the needs of the community, comma, with a specific focus on the northeast neighborhood. So we don't, if I don't live in the northeast neighborhood, I want to know that the council still values my area of the community, but you're identifying
That's acceptable to me.
Okay. And Bruce, we are, that was the one area that had been consistent enough in conversations with all of you that several weeks ago, Chris and I and his staff started putting that together, and it may end up being even more than 2 hours, but it's intended for just what you described.
Thank you, Bruce.
Okay,
Can I
great.
cover what I was going to?
Yeah, well, let me do this. Bruce, and then Peggy, and then Jim.
I really like what I'm seeing in the goals and objectives. I know from having worked with these before, with goals and objectives before in another setting, that as they are massaged and worked, they sometimes change a little bit. And I know we do, as a group, we have made little bit changes on some of these to get to this point. It's just natural that they're dynamic. I would propose that we as a council give recognition to the city manager that these are dynamic. And if they, at the budget session, are just a little different, but that's okay, because in the process of making them work, it was required to massage them a little bit. I don't want to get hung up on the specifics. And based on that, unless there was something really significantly here that we wanted to deal with, like go from 7 to 5 or 4, something like that, I would really like to, I think we're right where we can hand it to the city manager and say, go forth.
I would agree. Is everybody
I very much appreciate that. Can I just, for disclosure, can we walk real quickly through then, and I'll make it quick?
the quick edits you made?
Yes.
If you're going through the edits, can we comment on them?
Sure.
Since they're brand new, which
Yeah.
I would want to go back to the
Yeah.
very first one you
So I'm going to
said.
stand up here so I'm not twisting my back.
And so if I could comment on putting business in there,
Uh-huh.
the sentence doesn't focus on anything other than the business community that encourages citizen involvement. I don't think business belongs in there. I think the whole community needs to be vibrant economically, business, citizens, whatever, because that's how you encourage the citizen involvement, not just by having a vibrant business community.
Maybe Gilded the Lily.
It was intended for a family-oriented, economically vibrant community, one which encourages citizen involvement, respects diversity, values community character, and enhances the quality of life of local residents. So for me, economic certainly incorporates business, so we can get rid of it. And it is dynamic. If you change your mind later, throw it in.
Is everybody okay with business going
Once you
out?
do it by 12 o'clock tonight.
I don't, unless this is,
Anybody have any WD?
I mean, I don't know if we,
I know.
let's go through it, but
Yeah, I forgot that one was
wordsmith
there.
this to death is.
Scroll it down.
Just have no idea.
It's,
Sorry.
my one comment in taking some aspects of business out.
Hold on a second, I'm sorry. Bruce and then Phil.
I just, a quick edit, you got fire protection districts up there, just call them fire partners.
Okay, I just
Fire
put these
contract.
up here because they were things that, the big picture that you wanted to talk about on the 10th.
Okay.
But I will change that to the,
I didn't know if you were making it specific to just the
No.
district.
Just post it.
I was just making notes for Michael.
That's cool.
Phil, the hazard of doing
Sorry,
this.
I know.
Phil,
Okay, my concern in not having some aspect of business in our vision statement is coming from my discussions with a number of significant folks that are in the business community that still considers Littleton not necessarily open for business. And if we don't have something like that in there, I'm going to feel remiss that we've really missed something.
I don't have a problem with it in there. Let's show of hands, keep it in.
Business.
Okay, it stays
We
in.
say businesses.
We're just
Vibrant businesses, community. You guys wordsmith,
No,
but we'll keep
right,
business in.
Okay.
Okay,
Because it's intended to be separate with encourages citizens, so, all right.
So we got it done
Yeah.
by midnight, Michael.
Yeah, before Phil gets on the plane.
Okay.
wait,
Just barely.
okay.
Scroll it down.
Okay.
Okay, there you go. So we added, so we just added the northeast neighborhood. So on the objective, focus on, so it originally said focus on safety improvement opportunities. And so I wanted to be, a couple of you had talked about multimodal, walkability, use different words like that. So the intent was to be a little more illustrative in terms of we're focusing on all different modes of transportation, including accessibility, because some of you have talked about additional sidewalks, paths, et cetera, like that. I'm just going to keep going.
We're cool.
So here's some of the stuff.
Yeah, unless somebody
Objective,
screams.
partner with other governmental and non-governmental agencies to maximize effectiveness of providing a safe community. Again, comments around working with the other organizations, Arapahoe County, et cetera.
What's a non-governmental agency?
Some of the, there are,
Society.
The,
Yeah,
all the-
Humane Society.
Humane Society.
yeah, and there's some,
Well, you also have your CERT, the Community Emergency Response is not,
Salvation Army, Red Cross.
I'm good with it. I just,
all right.
I couldn't come up with it.
don't give us too long.
So there, I got a couple questions on provide and maintain a high-quality infrastructure that addresses the needs of residents. And to me, I am using, in this whole section, I'm using the word public infrastructure as incredibly inclusive. So I put in the word public here, so it was clear that it was everything. But when I think about this, just so you guys understand, since you're giving me some latitude and leeway in here, when I say develop an asset management plan to identify maintenance and capital improvements, I'm talking about everything from the sprinkler system to the buildings and the roads and everything that we have used public dollars for. Okay. There had been a couple of comments around 4 was pretty long, and we were pushing organization and community into that. So these 2 have now been moved to 7, and you'll see I've added the word trust into number 7, which just removed organization. And then incorporate discussion on the impact of property values as a component of the decision-making process. Got some concern that decisions that we could be criticized, that is fairly vague, so this is actually a question for you. Or actions, or a statement that says actions and decisions should follow a comprehensive review of all impacts and benefits, including the aggregate impact on the community's property value. And this was yours, I think, so I don't know if you have a particular, do you like one of the sentences over the other? Folks want to give Bruce authority.
Just say the second sentence.
Second sentence?
Number 2 is great.
Not just good, but great.
Bruce, there's 4 votes for the second sentence.
Go for it.
Okay.
There you go. All right. Dan asked if we would include density in our discussion on housing.
Oh, that's a good idea.
I didn't see any downside for that.
Before you,
Well, no, I'm okay with density, but I have to ask you, you've got an objective to update the 1981 comprehensive plan. There's more than a little history with that.
Yes.
So I guess I'm curious to know what you're thinking.
I'm thinking that ignoring a 1981 comp plan and trying to do sub-area plans under an outdated umbrella is worth having a conversation about.
Absolutely.
And if you'll give me that space to talk about it in February, that'd be awesome.
Yep.
Would it be worth also considering the Broadway corridor and Littleton Boulevard corridor as a part of that?
Yeah, to me, again, umbrella statement, I've asked Glenn, our Community Development Director, for those watching, to look at this and really start to put together a whole comprehensive plan of updates.
Okay.
And so we'll be presenting that to you as well.
Broadway, Littleton, Santa Fe,
Because you've already had
healthcare.
South Bay list.
So, at least on the comprehensive plan, can we put in continue to update? Because we are in the process of updating part of it already. It's it's not like just do it.
You haven't done anything.
And then, I have a question. So clarify for me what's going to happen after this, because I have, I think, some real serious feedback to give. So apart from that,
But this is your,
Your opportunity.
yeah.
well, I mean, we're whizzing through here.
Well,
so-
why don't we go through and see what Michael's edits have been, and then if,
So if you want to put continuing to update, continue to update the 1981 plan, I don't have.
everybody okay with that?
Sure.
Okay.
So should I come in on something else that's in this area?
No,
too?
let's let Michael
Let's go
get
through
through
his,
it, and then we'll come back
All
over.
right, we just took out the word comprehensive. Initiate a review of the city's development going down.
What is the improve the immigration thing? What is that one?
That is, Orly has some ideas about some expansion of the work that they're doing within the naturalization immigration program.
At the library you're talking about?
Yeah, within that area, not just within the library, but how to partner, again, with other, it'll tie into the Northeast. I think she's one of the folks that is involved in that, so she's got some ideas. I really
I mean,
can't.
the footnote to this is there's some cities across the nation that have dealt with immigration. I'm talking about the legal side of immigration, of course, and it's contributed to some vibrancy in their communities.
We'll get you more detail on
Okay,
all of
thanks.
this. because these will be fleshed out per our conversation last time. Promote policies and practices which sustain the environment. And this is where we move those two that had been in 4, and Bruce, in particular for you, Councilman Beckman, foster community involvement, communication, and trust. And so it's in a major goal statement as well as objectives that you've previously seen. Those are just cut and pasted down there. And I believe that is it.
That's it.
Quick question, I guess before on 7 there. The fourth bullet down, maintain and improve community spirit.
That was I think a carryover from, I don't know.
I mean, it's,
As opposed to killing community spirit?
Yeah.
yeah, I guess.
What can we do to destroy the?
Yeah, avoid killing community spirit.
We can kill that objective if you want. I mean, it should be implicit in all of our actions.
I don't know how you even measure it, though. I mean, you're
Smiles.
not going to have a specific project that talks about.
Oh, no,
I
but
think that came, so the way that this first built, and I think I told you we did a lot of edits, was
Yeah.
we looked at the 2012 budget, and so people were pulling out items that had been funded for that and group out. Yeah, and I think some of that comes out of the
It's a
marketing
welcome
realm.
week, something like that.
Yeah, it's just,
So are we getting rid of this?
but I will tell you that we will be moving.
Why not just foster community spirit? And apart from you not being able to measure how much you're fostering, I think that's an okay thing.
I'm okay.
With Foster?
Okay.
Yeah.
Change it
Just for
to
discussion,
foster
yeah.
community spirit. Cool.
Okay.
Okay, so,
But continue.
Pretty soon I'll be.
That's it?
That's what I.
so,
Nurture would be good.
Yeah, maybe I can give Michael this to look at and see if there's anything useful, but I will point out a couple things.
Please do.
Since I lost on that first one, I despair on the rest of them, but anyway. On number, on goal 4, and again, Michael, I'm not commenting on everything, so you can look at some others.
Okay.
And these aren't, when we redo this, maybe they can be given numbers or letters or whatever, so if we have to refer to them, we know what we're referring to. 1, 2, 3, 4, 5, 6. The 6th objective, evaluate ways to maintain Littleton as a community in which families wish to live. I'd like to make this for people of all ages to live, and not that we don't want to have families, but we want to have people, I think, of all ages, and that certainly includes families.
Is this a housing stock question?
Not
No,
necessarily.
I mean, there are all kinds of pieces that connect with that. So,
Yeah, it's activities, it's having, events and businesses that draw, but, so did you have a proposal on the sentence, or just say in which?
in which people of all ages wish to live. Then whoops, I'll let you get that.
everybody okay on that?
It is a different intent, without a doubt. I mean,
Yep.
it
Well, I see the families as a portion of the
yeah,
other
it just,
one.
it's,
Well, then, you got that family issue in your vision statement, so. The family thing, the family-oriented is right at the top of your whole document in terms of your vision to be family-oriented.
I guess I don't see it as being exclusive of other people. I think it's calling out families because at the end of the day, they support the schools and, they've got the larger impact. I don't really have a problem with it as a issue related to that. Phil?
Yeah, in,
Bruce 3.
I knew I was going to do it.
whole thing.
It's just a funny joke.
okay, all right.
In this one, in the absence of taking a look at what specific programs are there, I would leave families.
Show of hands, leave families. Okay, so he stays.
All right, just.
Okay, so then let me raise a question. One of the things it seems Littleton needs to do is to make sure that it attracts people with disposable incomes. And some families can do that, and some families can't have disposable incomes because they're spending it all on just getting by. I'd like to see somewhere, and I don't know how to phrase it, something that says, that would get at that, right? Because we could theoretically turn this into, and I don't mean this bad, so if anybody's listening in the audience, television, these right now, I don't mean this in a bad way, but we could potentially have everybody in this city needing government subsidies. And that's not what we, potentially. I want to make sure that we keep being attractive to people with disposable incomes, as well as everybody else, that we are someplace for a wide variety of people, but including people that can and will spend money.
But Peggy, wouldn't that be an action plan that could fall underneath this strategy? And the action plans, we're not getting into that detail with this, but that to me would be an action plan that would fit.
Well, I see it as
I still see, well, if we look at goal number 5, which really talks about we need to have a sustainable local economy. I mean, I hear what you're saying, Peggy, but I don't see it under that particular item. I actually see it as a higher goal.
Okay.
Well,
Bruce.
whatever, I just don't want to lose it.
Okay.
Bruce.
Well, and again, to go back to the vision statement, I mean, right in there, we talk about respecting diversity, so there's an element of respect with respect to income diversity as opposed to any other kind of diversity.
That may be so, but I don't know that that's what most people would normally think when you say that. So, anyway, I just want us to not lose certain things here that are really important.
Go ahead, Bruce.
Well, I'm sorry, I was just going to ask, let me then backtrack, I guess maybe this issue as well. Maybe it's in here, but, you know, part of this, both the issue of all stages of residence, all life stages of residence and income diversity and disposable income and so forth and so on. Where did we address, or is there an objective in here vis-a-vis diversity of housing stock? Is it in here?
We've got the evaluation
Where is
of
it?
it.
It's under objective 4, and it is objective 1, 2, 3,
4.
Evaluate
4.
diversity, density, and quality of community.
Okay, good, great, okay, thanks, I missed it.
But if folks are comfortable with the intent of Peggy's comment, I can work to incorporate that in, and based upon Phil's comment, probably end up with it under goal 5.
Actually, I'm not.
Oh, okay.
I don't think it's our role to make any judgments on people's disposable incomes. There could be a family with a disposable income of $20 a month, and there could be another family with a disposable income of $2,000 a week, and that is not our business. We provide housing, and they have to qualify for that, and that is out of our control. Littleton Housing Authority, they've got their way to qualify. There are prices for things, and people can choose to pay for those with cash or credit. That is all personal financial decisions. We provide a community that offers a variety of things and cost, price points, et cetera. We've got savers, we've got a pottery barn. And I think that attracts people to at whatever income they have. That is not where I feel comfortable going.
I'm with you, Mary. And I think having children doesn't mean you don't have other money. I mean, Larry knows I had a couple kids, and we spent a lot of money. We dropped a lot of money throughout Littleton throughout the years. So, and that was a good thing for Littleton. So I don't think just because you have kids doesn't mean you have disposable
No,
income.
I did not say that. I just think that we want to make sure, we've had historically some really exceptional diversity in this community. It's wonderful. I mean, I've been here since the late 60s. And we've lost some, I think, of that attraction, in part because of the aging of the people who came to fill certain kind of jobs that, particularly when we, Martin Marietta, encountered its difficulties. We didn't keep quite as many people with relatively high incomes. I want to make sure we don't lose that piece. I said nothing about opposed to having families. I love having families. And some families, well, you said, their families are all over the range in terms of that. But anyway, I did not mean to imply something that seems to have been heard.
Well, you were saying that for the TV audience, but I think we lost the TV audience a long time ago.
In the way that I see that, if I carry out, and it is getting late, and I think it was Bruce that asked the question where the housing stock is. To me, if we have a diversity in the type and quality of our housing stock, that's where that comes. Because if you have a different price point, that you're going to get lower income people who are going to do this, and if you've got a middle class that can afford this and a higher end that the 1% can afford, it is late. But to me, we can get at your concern through the evaluation of the housing stock and looking at our land use and zoning code to allow a variety of the housing stock.
Yeah, and I had another one of what I'll give you if you can read my writing related to what you just said.
Okay.
In Goal 4, what is it, the next to the last, to develop a policy statement that addresses the trade-offs, et cetera, et cetera. I thought we were getting that with the task force on parks, open space, and so forth. So there may be a little bit better way to word that ties it in with what's coming forth from them.
And the mayor can speak, or Phil maybe to this, but I read the directive to the task force, and I wasn't 100% confident that what the outcome of that was, that you were going to end up with a policy statement that dealt with the trade-off.
And you are not.
So
Just don't expect that.
Okay.
Because that was not part of our directive.
Okay, but
that's where that came
task
from.
force is supposed to be looking at those trade-offs when it makes recommendations.
Yeah, there's, where we're at is there's certainly considerations, but it's not a policy statement.
Yep.
So
No, we're not making
Okay, so
any
we may
policy.
translate that into policy?
Or you may come up with a separate
Okay,
policy
all
statement,
right.
but that was the intent from that, and that is where that evolution came from.
Your
Then-
task force is making recommendations.
Then number 5, the last one, I didn't know what in the world that exactly is meaning. Facilitate the attraction of city-sponsored events and community resources?
I can see where that might apply. For example, well, I don't know whether city-sponsored or just community
Okay,
community
let me
events.
put it in some way. I mean, we have some things like Western Welcome Week and the 4th of July celebration that bring folks to downtown, candlelight walk and such. I see this as saying, okay, let's put it on the whiteboard and see what else we can do.
Well, are we facilitating the attraction or the attractiveness? We're not trying to attract.
So I think some of it is, okay, Hudson Gardens didn't have Hudson Holidays this year.
Okay, but the one you just gave before sounded like the other, so that's part of where maybe we need two different things, I don't know. So I'm just putting that out there, because I was...
So you're saying it sounds like the marketing of?
Yeah.
Yeah.
Well, it either means let's attract some city, let's get more of them, or let's promote and make them attractive or whatever. I mean...
Okay.
Yeah. I mean, so.
And...
Are people opposed to doing both?
No,
Looking at doing
no.
both?
No, that was part of why I was wondering which the focus was, so. And then, whoops, were you going to comment on that?
No, that's okay.
Then back up in 4, I saw one, 1, 2, 3, whoops, 1, 2, 3, 4, 5 up from the bottom, develop a plan for youth and government, blah, 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 blah. Doesn't that belong under 7 with the communication piece?
Community development, it would make 4 shorter.
Yeah, do
Anything
it, yeah.
to move, make
That
it.
sounds, yeah, that sounds good.
Okay, move it to 7.
Okay.
Wait, where are you? Sorry.
Develop a plan, I'll,
Develop.
that whole one
This?
goes to 7.
Okay, Peggy, do you have more?
And, Michael, I'll give you this, and hopefully you can
Okay.
read my scribbling
sure I can.
and get it to me.
But we hit the high points?
Get it back to me, pardon?
We hit the high points?
Yeah,
Okay.
yeah.
But add her comments, but put them in pink or something so we know which ones are hers.
Pardon?
So we know which ones you want to add in there.
Yeah,
No,
Yeah, we-
no, these are tweakings of wordings
tweaking.
or asking a little clarification that we don't need to go
Non-substantive.
into.
does anybody else have anything? Jim?
I've got 2 things that I'd just like Michael to take a look at.
Okay.
Somewhere, and I put it under 4, but it may not belong there, is something about elderly services, because you're going to get a lot of information later this month about elderly services and some suggestions of what may happen. And someplace, and I had it under 5, about economic development for the community.
Yeah, and you probably noticed a lot came out between this one and last one on 5 in terms of the objectives, just pulling those out. So,
And if I could-
yes, I
Can
can
I
throw
come
something.
in on what Jim just said about the elderly services? That, to me, comes in terms of trying to make this a place where people of all ages want to live, and then the sub-piece of that is providing elderly services, providing services for other people, whatever. So, but that's part of what I had in the head.
Phil, and then Bruce.
And as you're taking notes, Michael,
Yeah.
I'm not going to worry about positing these in a particular place, but this is in addition to that email that I sent, just to make sure that they're not lost, which is consideration around planning academy, that concept. It's been out there. I don't know what we do with it exactly. Thought around operational audit of the wastewater treatment plant.
Yep,
And then the other is the taking a look at our southeast quadrant and the healthcare complex. What can we do, or what do we have on the books that may hinder some of that? So we
Bruce?
can make it stronger.
I think it's the last one.
I got
2 items, sort of on number 5.
We can hook up.
Do we need, economic development's broad, and this may be sort of, you may have a lot distilled into strategic assistance to Littleton businesses. I guess 2 concepts. We've got businesses that have massive diversity in terms of their target markets. I guess on the one hand, it'd be interesting to understand, I don't know that I'm seeing one size fitting all necessarily. So it might be interesting to figure out, and maybe this is an action item, but do we do something like survey various levels of business to determine what would be of greatest value to them in terms of reaching their objectives? Maybe that's already part of BIA and economic gardening. I don't know. I tend to think it's broader. I tend to think it has more to do at some level with making it easy to do business in Littleton. The whole customer service concept, which I think you've got baked in. But I look at things that'd be value added for certain businesses might not be value added for others, and we ought to figure out how to meet the needs of the diverse business community as best we can.
Work with Chris on that.
Yeah, and I think we can come up with some good language, because it's all, obviously we want to recruit new business, appropriate new business. We want to help those that are here, retain them, and then those that want to grow, we want to expand.
Well, I also think
So-
yeah, I agree with that.
And
but
there's not a one stop or one fit for that.
No, I
Any
agree.
one of those 3 groupings.
Yeah, I mean, I think, as well, just, there's, all you gotta do is walk down Main Street, there's a very broad view to what's beneficial, and some of it's physical space, some of it's, what does the physical space downtown look like? I think that's an element of it, too.
Phil?
Just to piggyback a little bit on what Bruce said, and to kind of position some of where that survey of employers that the chamber is doing, which will give us that, but also in my having sat down with Chris and Michael, I think BIA, the department, has a lot more information about what businesses are looking for than we see.
Yeah.
We meaning the council in this instance, and some of it may be packaging some of that information. So.
Yep.
Can I, one little tweak, because this is more than just a little one. Back to the vision statement. I'd like to add to the sentence, "and visitors," at the end. Because we want to attract people whose life is enhanced here, therefore they come and shop and do stuff like that.
Let's call them outsiders.
Outsiders?
Just joking.
Them and us.
Outsiders.
I mean, we do it right now, we do attract people, and I want to preserve.
Everybody okay with adding visitors?
I think that's a good idea.
Maybe they'll come by a house after they've been here.
I walked the mayor of Golden up and down Main Street today, the brand-new mayor of Golden.
Perfect.
Okay,
All right, so I will,
no,
I was summarizing.
okay.
But-
We don't need to summarize.
No, I was going to summarize
Do you
the
need to
process.
summarize?
No.
Do you need to, we'll put the process.
This will come back to you on the 17th.
I'm
Expecting
you.
a summary.
That was my summary. This will
Very
come back
good.
to you on the 17th, but I realized maybe there was,
Did you want to talk about paperless, or do we move that?
we can move that.
Move it.
Move it, don't do it tonight.
Okay, in which case, if there's no other business,
We are moving
Are
forward
adjourned.
on it. Okay.
okay.